Good morning, everyone. We're going to call to order the Wednesday, March 13th Board of County Commissioners meeting. Apologize for the delay today. We were involved in some follow-up interviews for one of our department positions, so we were kind of shuttling between people and things, so we just got all that done. But welcome, everybody, and if you'll join us in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you all for joining us today, this meeting. If you haven't been here before, this is all recorded on both audio and TV. You can follow on the Deschutes County website. So when you're speaking or when we're speaking, you should be able to hear us in the room. You want to speak loud enough into the microphones so that you can be heard as well. A couple of things before we go on. We have blue forms like this. These are requests to speak. We're going to do the first item of our business is the citizen input for things that are not on the agenda, so that if you want to speak on anything that's not on the agenda today, you need to fill one of these out also. If you haven't, you can fill it out after you come up and speak, but we do that. And then if you're going to speak on one of the items on the agenda, you need to fill one of these out also and give them to Sharon, who will give them to us. And we've got a stack of them for both of our hearings later today. But you can do that anytime during the process. But that's those blue sheets are somewhere up here. If you're the appellant or the applicant, you don't need to fill those out. You're as part of the hearing process. So our first matter of business is citizen input. Is there anyone that had anything to speak about before the rest of the business meeting? Okay, seeing none of that. Our next item is the consent agenda. I know that we've had a chance to review all the minutes. So
this is the same set of minutes from last week's board meeting, and I have done my homework on those, so I'm supportive of.
So you get a good gold star. I haven't had a chance.
Okay, that's fine. I'll just let you know I was prepared.
I've read several of them.
Okay. Well, let's try to get them done for Monday.
Okay. Standing by.
So we've had a busy several days in Salem and then here.
So consent agenda, I'll move items 1 and 2, and then minus all the minutes.
Okay.
I second it.
Any further discussion? Commissioner DeBone?
Yes.
Commissioner Dare?
Yes.
The chair votes yes. So our first action item then is a second reading of ordinance 2019-006, the East Side Plan Amendment and Zone Change. And Nicole's going to join us for that.
Thank you, Chair and Commissioners. For the record, Nicole Mardell, Associate Planner, Deschutes County Community Development. So this, before the board to consider today, is the second reading of ordinance number 2019-006. This is following a public hearing and deliberations and first reading that was held on February 27th, 2019. So you have that ordinance in your packet, and I welcome any questions if you have them.
Commissioners, any questions? I think we've talked about this previously. So then I'd proceed with the second reading, and then we move approval. Is that correct?
That's correct.
Okay. So this is the second reading of ordinance number 2019-006 in title only. An ordinance.
A motion to do that is kind of the procedure.
I thought the motion was to approve it. Do we need a motion to read it too?
You could go either way on the reading of it, but you do need a motion to approve it.
Okay.
I'll stand by.
Okay. An ordinance amending Deschutes County Code Title 23, the Deschutes County Comprehensive Plan, to change the comprehensive plan map designation for certain property from agriculture to rural residential exception area, and amending Deschutes County Code Title 18, the Deschutes County zoning map, to change the zone designation for certain property from exclusive farm use to multiple use agriculture. So I'd seek a motion then to approve that.
I'll move adoption of ordinance number 2019-006.
I'll second the motion.
Any further discussion? Okay. This is a matter that we had a hearing on, and we've didn't have any opposition, so I'll call the vote. Commissioner DeBonne?
Yes.
Commissioner Dare?
Yes.
And the chair votes yes.
Here we go.
Thank you.
Yes, thank you.
Thank you, Nicole.
So the next order of business, I believe, is the continuation of the hearing on let's see. Matt, are you joining us for this on the marijuana appeal of a marijuana production appeal at 70355 Mackenzie Canyon Road in Terrebonne? We took oral testimony on this last Wednesday, and it was during the kind of the height of the snowstorm and snow challenges, and so we figured there may be some people that weren't able to come testify, so we left the hearing open, which we don't typically do for oral testimony, and then probably written testimony later. But so we'll have further testimony up to 3 minutes from people that have turned in a blue form on that, and then the applicant of that proposal use will then do a rebuttal after that. So that's basically the order of things for today on that hearing. Is that correct?
Yeah, and just additional comments, and to reiterate the continuation of the public hearing from last Wednesday regarding marijuana production by Ted Price of Mackenzie Canyon LLC, Mackenzie Canyon Farms LLC. I do want to acknowledge that since the public hearing on last Wednesday, have received some additional record submittals. One from Peter Russell, County Transportation Planner, addressing transportation-related topics that were brought up at the public hearing. That was submitted on March 7th. And then 2 messages from the appellant, Mr. DiPaolo, were received on March 11th. So those have been submitted into the record. I do have copies of those if you're interested at this point, but certainly will be provided to you directly for consideration.
I think we would be interested in those now, and actually, if Mr. Russell, I don't know what the right time for him to talk about them would be, but I'd probably be interested in having you kind of brief us on what, as you know, our staff on that, on whatever the issues were that you dealt with. So maybe we can get your copies, and then you can talk. Or do you want to hear from him?
I do want to hear, please.
Okay.
Thank you.
And it kind of gets just back to the terminology, because there's different exchange terminology sometimes.
Okay. I'll wait till Matt's passing you some stuff out. So what you have, morning Commissioners, Peter Russell, Senior Transportation Planner for Deschutes County. In the memo, I'll boil it down into a couple bullet points. Essentially, during the public hearing, there were several questions raised by the attorney's applicant and the public as well about Mackenzie Canyon Road, its condition, what the county could do to it, things of that nature. So first, I'd point out, because of the size of the grow, being under 5,000 square feet of mature canopy under our applicable criteria, there is no transportation. It's not a germane topic, but because the board had, it's not approval criteria, but because the board had asked questions, the public had also mentioned it, I thought, well, let's just give you the information, as even though under the approval criteria, it's not one of them. So Mackenzie Canyon Road, ballpark, it's 6 miles long. Almost the entire length is a private road. So the county has no authority over a private road. There is a small section of road that's public, that does not serve the subject property. It's north of there, and that's what the county calls a local access road. So a local access road is a public road. It's a public right-of-way that was dedicated during a partition or a subdivision, usually predates the county zoning standards. By state statute, the county cannot spend money on a local access road, except in certain emergency circumstances. So in essence, the county has no regulatory authority, we have the regulatory authority to do an access on the local road portion, but that's all we have. And the local road portion isn't by the subject property. That's a private road. In terms of spending money, we have no ability to spend money on Mackenzie Canyon Road because, 1, it's a private road, and 2, the part that's a public road is a local access road, and state statute precludes that. So then there was some discussion, well, what could it be brought into the county maintained system? So we've had a road moratorium since 2006 at the county. In the 2009 update, and these are all in your packet, that road moratorium was modified. That gave the board the discretion to bring in an arterial or a collector. functional classification of Mackenzie Canyon Road as a local road. So even under the revised moratorium, the board has no ability to bring it into the county-maintained system. And then, again, let's just say you could, both county and road department staff feel that there are other higher-order roads that we have that you would spend the money on that, and you wouldn't bring it into the county-maintained system. And then the last issue that came up, well, there's roughly a $20,000 transportation system development charge that has been assessed against this marijuana production. Could you put the SDCs to Mackenzie Canyon Road? And again, by the board resolution, we can't. We can only spend SDC monies by state statute on public assets, as well as by our own resolution. Again, Mackenzie Canyon Road's a private road, so we can't spend money on that, and that's why you can't put the SDCs into Mackenzie Canyon Road. So that's kind of my memo distilled into, a 1-minute blitz. I'd be happy to answer any questions that you might have at this time.
Any questions?
Also, and this may step out of your jurisdiction into kind of the legality of what a private road, who speaks for the private road, who has access to the private road, and how can it be, discussed in an application like this? As I say, that may not be your domain.
Right. So first off,
Say some words about that.
access isn't one of the approval criteria for this particular land use, the size of the mature canopy. So the maintenance and operation of a private road is on the adjoining property owners. Typically, they can form a special road district, which is another governmental entity, which gives them the ability to regulate. You do it by a popular vote. They work with the road department and the board for that, and then they can establish fees for every household along there to pay for the operation and maintenance and enforce non-payment. So that's one option that people pursue when they have a private road. There's the informal one that the residents have talked about previously, where it's kind of the pass-the-hat route. But the special road district gives the legal authority to collect fees for the operation and maintenance of a private road.
I guess I'm getting to the concept of does the public have the right to drive on that private road? Connectivity in our community?
Not public roads, so no, there is no public right.
Yeah.
Public can only drive on public roads that are either in the county-maintained system or they're dedicated to the public. So like a local access road is a public road.
Yep.
So you have the legal right to drive up and down it, but a private road by definition is private.
So the applicant, being a property owner on that private road, has an equal say as other property owners, is what it boils down to.
Yes.
Just following up with that, so do I have a right to go out and drive on that road, or could they put up signs saying no trespassing? And
Well, I'll turn to Dave, but yeah, I mean, a private road by definition is, it's gated communities have private roads. You control who uses that.
so the people that live there can basically keep out anybody they don't want on it.
I understand a private road, yes. Now, there's all nuances of have you established a right of travel by adverse possession? So if I drive up and down your private road for 20 years, and then on 20 year and day one, you go to stop me, I'll say, well, I've established the right of use by open notorious of going up and down. So, but again, I defer to Dave for getting in the nuances of that.
Peter, how far is it from the grow site to the public road then? If you're going north, do you know how far it
To
is?
be honest, I don't. I'd have to get on dial and measure it. I'd just be guesstimating if I were to say. I'm sure some of the folks who live here probably know it down to the 10th of a mile, so I'll defer
Okay.
to them.
But
All
it's less than 5 miles. I mean, it's kind of the grow is kind of towards the north end of the
Yeah.
road, so there's a section.
Right, it's closer to Lower Bridge.
We've seen that. Yeah.
Lower Bridgeway, much closer. So again, if you were doing a traffic study, you'd put most of your traffic through that intersection of Mackenzie Canyon, Lower Bridgeway, because it's the closest one to get to and from, instead of going all the way down to Holmes.
So I have a question, kind of a follow-up to what I was asking the applicant last week. So they came in at 4,960 or whatever square feet of mature grow. And I really challenged this idea that they would stay below 5,000. It seems like the only benefit to stay below 5,000 would be to not have a road access issue requirement. But I could be wrong. Maybe there's real business reasons, but I'm not sure. If they were ever found in noncompliance, that they had 5,010 square feet of mature canopy, would this access provision in our code kick back in where they would not have a right to access? In other words, would that be a code violation in a sense, even though they can have more than 5,000 mature on the size of the parcel, they didn't have the road access. Because we have that quirk, which we've changed in our regulations, so the road access is for all. But
So working through it, if there were a code enforcement complaint filed, they'd have two avenues. One, they could remove the amount to get back under 5,000 square feet and be in compliance with their land use approval, or if they were to stay larger, we'd enter into a voluntary compliance agreement. They'd have to resubmit a land use application for that additional size. And then it'd be a whole round of notice hearings and.
But it wouldn't, see, if they came in with an application for 5,010 now, that ordinance would come in and they'd say, well, you don't have access that meets the ordinance, and that would be actually a reason the application wouldn't be approved. So if they're out of compliance, there's other ways they would be able to come back into compliance, reduce the grows, size, submit a new application that got through, okay? And I don't know what they'll do. I don't favor the complaint-driven approach to making sure that everything gets done. And okay, all right. Any other questions from you, Commissioner?
No.
Okay, thanks for giving us some additional information. That was something we talked about a lot last week. Okay.
I may also, what I'm distributing are the two messages from Mr. DiPaolo that were received on March 11th. Having done to answer your question about distance from the public right-of-way portion of McKenzie Canyon Road, public right-of-way is approximately 1,720 feet to the northeast of the subject property. So it's about that.
How far?
Distance. About 1,700, 1,720
Feet.
feet.
Okay. So, Mr. DiPaolo, we appreciate the new, the new submittals. We won't be able to have, you testified before, so we wouldn't be able to get new testimony unless somebody else wants to testify to this information, but we have in the record. So, anything further? So we do have some people who want to testify today on this. The first is Amanda Clark, and then next will be Ruth Parks. If you want to come up and speak into the microphone there and give your name for the record.
You want address as well, or?
We have your address on the form. Thank you.
Okay. My name is Amanda Clark, and I want to say thank you so much for continuing this and giving us the opportunity to speak as well. So to give you a little bit of an update, I know that the proposed grow operation is actually probably only around 1.5 miles down the road. Right now, it is single track. If you meet somebody, it's my only access out to take my children to school, which takes about an hour right now in Sisters. If you meet somebody, you have to back up to the next driveway down. That doesn't sound like a long distance, but when you're talking about conditions like this, it's quite long. We've lived there for about 7.5 years. I volunteer on the Sisters School Board. My husband is a Bend fire captain. When we purchased that property and were looking at it, we knew that there would be inherent risks and challenges. We were almost at the end of our home buying process, and we were trying to secure property insurance. And we found out at that point that we couldn't it was going to be a real challenge because there was no fire coverage. We have no fire district covering our area. Clearly, I used to be a volunteer firefighter, and my husband's a professional firefighter. That was a concern for us, a major concern, and it gave us pause. We felt like with our training and expertise, with our consistent presence in the property, and our commitment to mitigating risk factors and managing our property, that was an acceptable risk for us to assume. There have been fires and issues on the road, and the residents help each other out. We assume some risk for each other, and it's assumed that we will be there for each other if something happens. We do not assume risk for this grow operation. This is a massive operation potentially. There are things like fertilizer, grow lights, a lot of things that concern me deeply. And with nobody on the property, it's left to the residents to manage that risk. And I think that's an unreasonable expectation. The sheriff is 45 minutes away, so even that is a long shot for any assistance. In conclusion, I will just say, in my opinion, between the electricity challenges, the road, and the lack of fire or sheriff response, this is just, the infrastructure is simply not in place for something like this on our road. We all of us who live here or on Mackenzie Canyon have made the choice very purposefully to live there because of quality of life, and this is simply not something we signed up for. Thank you so much for your time.
Any questions or?
Thank you, Amanda.
Thank you. Next is Ruth Parks, and then William St. Clair.
Good morning. My name is Ruth Parks. My husband and I bought our property in 1997, and I considered Mackenzie Canyon my home ever since. My major concerns are safety. They've been adequately covered. I would like to say I have a concern about the agency that regulates compliance. They are woefully understaffed, overburdened. There's this huge gap that exists between what is actually going to be checked and what any applicant agrees to do. This is very scary and very dangerous, but it's going to allow people to do whatever they want.
Are you
And
talking about the OLCC?
Pardon me?
Are you talking about the OLCC that does compliance, or are you talking about the county? Or do you know?
Of the above. The other thing, I think that there were enough legal issues brought forward that the commissioners could easily honor the appeal on sound legal grounds. But there's a bonus. Because you are protecting a whole community, and Mackenzie Canyon is a community, the bonus is you're on sound moral grounds. And I'm asking you to please honor the appeal. If you have any questions, I'll answer them to the best of my ability. Otherwise, thank you for your time.
Questions?
How close,
Thank you.
how close do you live to the intended
I
site?
have to ask help.
You have to ask?
How close do we live? Quarter of a mile.
Okay, all right, thank you.
Okay, thank you very much for your testimony. The next one is William St. Clair.
He may have testified.
What's that?
Okay, the letter that's attached.
We've got a letter.
Okay.
Oh, okay, so this is just a letter, okay. Okay, good. Anyone else that wants to testify with regard to the application itself or the appeal, other than the applicant who will do rebuttal? So, seeing none, that we'll go ahead and have the applicant can come up and give their rebuttal to things they heard today and things they heard last week. So it's an inclusive rebuttal of all of that. So, yep. Yeah.
Oh, there you go.
Yeah. Tell him he's up. Tell him he's up.
Good morning.
Morning.
I'm Dave Mullen, one of the partners in Mackenzie Canyon Farms, and
I'm Ted Price. I'm the other partner and head of cultivation.
just going to hand in some notes.
So we've got,
or rebuttal.
is this the notes?
No, this is specifically for rebuttal. So in addition to what we gave you last Wednesday. I don't think we've given these. Yes.
Where'd you get these? Where'd you get?
It was handed to me. Where did he just? Is that the same? Yeah. So yeah. Okay. We got the first copy. Of
Oh,
it,
okay.
so we'll just got
Okay.
the rest of them.
So, yeah, he'll take one there.
Okay.
And then there, if you got one. So this is notes to
To support.
support the
Yeah.
rebuttal.
the
Okay.
rebuttal, yeah.
Okay.
Great. So from the hearing last week and previous information entered into the public record on this matter, we've heard lots of conjecture, and not in my backyardisms as well, is kind of what I've taken away from it, from both the appellant as well as some of the public comments submitted. We appreciate the fact that change can be alarming to people, and that it's very common to overreact to impending changes, such as what our business is. From my own experience living and operating businesses in the vicinity of various new building developments and road expansions, I've lived on the NIMBY side of the table as well. And I can say that for me at least, more often than not, at the end of the day, the change has been much less than originally feared, and in some cases when it was even an unexpected happy improvement to the quality of life and work. I'd like to now take some time to just rebut some of the conjecture and misstatements of fact that have been put into the record last Wednesday during the first hearing. Number one, we have no intention to show the Fosters in a bad light. By providing the 911 records, we simply believe that the facts from those records aren't conducive to the claim that a youth activity center is operating on that property. As discussed in the March 6 hearing, it's up to the commissioners to weigh the relevancy and significance of those facts. For the record, the applicant is not the originator of any of those 911 calls regarding the neighboring property. Regarding the 911 call specifically to investigate an elk hanging on the property for a lengthy period of time, the applicant's attorney claimed it was a pig. The appellant's attorney claimed it was a pig. The applicant never witnessed the scene and was not the source of the 911 call. The sheriff's deputy that responded to the call reported it as an elk after his own visual inspections. In either case, any animal left hanging on the property for an extended period of time does not seem appropriate for a youth activity center for health reasons as well as possible safety issues by attracting predatory animals. 3, we have continued to have discussions with the Oregon State 4-H office. They continue to confirm that Kelvin and Amanda Foster and Stephen Calavan are not 4-H leaders, and there is not an active 4-H youth activity center authorized on their property. We have also now reached out to, at the state level, Marilyn Leifmeister, who is in charge of the Oregon State 4-H Volunteer Development and Risk Management Department. She confirms the information we provided last week from the Deschutes County 4-H rep, Candy Botmeyer, that there is no 4-H youth activity center, then the Fosters and the Calavans are not 4-H leaders. Marilyn from the state office has requested, if written confirmation is needed by the commissioners, that the Deschutes County attorney should request directly from her, and they would be happy to provide. I've included Marilyn's phone number in the record.
Can I ask you a question about that? So you've made the case, and I don't know that it's really been rebutted by anyone, that they're not 4-H leaders. Does that necessarily mean they don't have 4-H activities? I mean, maybe it's a better farm to have activities, and so somebody else is the leader and they have it at this property. And I don't know if I've heard evidence on that, but are you maintaining both don't happen? There's no leadership and the activities don't happen?
Nothing's been entered into the record by the appellant that some other person, in fact, if you read through the record, you'll see that they specifically claim that Calvin, for sure, is a 4-H leader, as well as a Future Farmers of America leader, excuse me. And
Calavan.
And Calavan, I think his name has been associated. I don't know if in the record anyone specifically called him as a leader. But the net of it is nobody from the appellant side has indicated anybody else coming to conduct. They've been very specific that it's been the Fosters, to the point of having just activities there, and whether you call them 4-H or not. One thing in both talking to Candy and Marilyn at 4-H is they actually have expressed concern and has indicated that they would like to, or they intend to, deliver written communications to the Calavan and the Fosters that they are not allowed to claim they're 4-H leaders or have a 4-H property. We've asked them to wait until this proceeding's over to do that, but that's what they've indicated. And again, you're free to call Marilyn directly at the number provided, and she can confirm the statements that we're making.
Thanks.
When you get into, I went back and read through the burden of proof and what the county staff came up with in their findings, and they were very thorough in addressing youth activity centers, and really I asked you to go back, read through that, and focus in on the part where they talk about the fact that you can just bring some people randomly onto your property and call it an activity does not make you a youth activity center. It's having friends over. It's an informal gathering. It's not an official youth activity function.
Yeah. But, and just as you know, your decision was made quite a while ago before we'd actually interpreted the youth activity provision several times. And so it's evolved since the hearing, our staff decided yours. So that's why I'm kind of focusing on, are there meetings there? I mean, we have said that, that's probably a factor in making that decision. So we're just, we'll have to look through the rest of the record, but it seems like mostly focused on they're not leaders, but I haven't seen anybody say, well, there's never, I live next door and I've never seen any meetings, so I'm just wondering that, but anyway, good, I get you. Yeah, thank you.
Short of some kind of evidence or proof that these things have been happening regularly in some authorized way, I can only assume they're not.
Okay.
That's our position.
Okay.
4, appellant's attorney raised our relationship to the property owner as an issue for some unknown reason, and we just wanted to clarify the record that we have a lease-to-own contract in place with Dr. Marianne Bertotti, who is the record of owner of the property currently. Number 5, appellant's attorney spoke extensively about large numbers of deer ranging between Redmond and Sisters. I'm not really sure where she was going with that, other than to rhetorically say, is she saying that no recreational growth facility should be allowed to operate in the entire area between Redmond and Sisters because of all the deer? Number 6, much is made of the golden eagles in the canyon. We have reviewed the email submitted on March 6 by Emily Wiedner from, I believe, she's a wildlife and fish biologist with the Forest Service, I believe. We acknowledge from her letter the half-mile nest disturbance buffer during the nesting period. We further acknowledge that no construction activity will occur within the nesting period, or if it does, a proper permit will have been issued to us. Number 7, applicant commits to road upkeep and has actually contributed when, as was mentioned, the hat was passed around. We have contributed to the road already. We believe the neighbors will be satisfied that we will do more than our fair share of road upkeep over time. Number 8, applicant's attorney raised numerous times that Deschutes County Sheriff is not in favor of our application. We understand that he is biased against marijuana from his public comments in the news and other public forums. The bottom line is that we have met the standard for the issues he has raised of noise, odor, and security. Number 9, appellant's attorney and public comments keep raising the issue of well water. For the record, the applicant is not utilizing any well water for marijuana irrigation. The only reason we put well water in there is because that was a requirement of the land use application. They were asking questions. Do you have a well on your property? Where's your water rights? We have no intention to use the well water for irrigation.
We get a little bit more clear on that. So it was mentioned during the testimony that there's, later in the season, there's groundwater rights to supplement agricultural water, if I understood it correctly. So are you saying that even if there's agricultural water available through a previous right to a groundwater source, you won't utilize that?
That is correct, because my understanding going through the OLCC application process, there's documentation in there that actually says you, at a federal level, I believe, or state level, you are not allowed to use well water for recreational marijuana cultivation.
Yep.
So that's
So
what's
there's a
driving.
clear line there already.
Exactly.
So just a little bit of follow-up. So as I understand it, the Three Sisters has the irrigation water that now is piped through there. And so this is a supplement. I'm assuming if that runs low or something, or at the end of the season there's not adequate supply, so your neighbor may continue irrigating from this well for their hay crop. I think there's 4 parties to this agreement or something.
Yes.
But you can't continue, or you could even do it on your hay crop. I think there's hay on your,
Yep.
if you went into, but you can't, you're saying you wouldn't use it on your marijuana crop.
Correct, because my understanding from, again, as I mentioned, either the state or federal level, it's illegal to do that, and so we will not do that.
Do you know history, how soon that water right runs out some years? I mean, does it, the irrigation canal or piping?
Not off the top of my head.
I think it all depends on the water level that we get during the winter months and stuff like that. So it can fluctuate, I think, during the year. We've only owned the property now for 2 years. This past year, there was a little bit of a flow issue for about a week right off the bat where they went down to about 30 PSI, and then it was fine for pretty much the rest of the season until towards the end of the season where it started diminishing down.
Okay.
But
Okay.
Great.
Number 10, and this kind of follows on to that point, we went back to Three Sisters Irrigation over the past week, and they have, again, advised us that applicant, us, that the irrigation canal water can be used for marijuana production. We also reached out to Linda Thompson from Three Sisters, who actually spoke to the Oregon State Water Resource Office, the Water Rights Department within that office, and they indicated through her that no permit is necessary to store irrigation canal water, and in fact they encourage the storage of that water for agricultural needs outside of the date that the irrigation canal is operational. And we're working to get written comments that support that from them as well, so you're not just taking our word for it.
Are there any limitations to how much you can store, or how?
No, they were, have said they will be getting back to us with more detail on that. But we let them know the amount of water we're looking to store, et cetera, and they're doing the research and said they would get back with us.
Okay, thank you.
And
So
whatever,
they're writing a letter.
we've asked them, yes, to write a letter to us. 11, CEC, the Central Oregon Electric Co-op, has informed the applicant, this is previously, so I'm just reiterating, that they are responsible for protecting our power access due to the fact that they neglected to acquire an easement when power was brought in and the properties subdivided originally. So they kind of have said, you're grandfathered in, and it's their responsibility to make sure that whatever power we do have, that is maintained. We understand the limits on upgrading the power at this time, and the applicant has made a business decision, as we discussed at length last Wednesday, to operate on a limited scale until such time as additional power can be brought to the property. Before I go into the closing, just to add from some of the remarks I heard from this morning, again, our business plan is to be a craft cannabis producer. We have no interest or strategy to grow beyond the Tier 1 mature canopy growth that we have applied for, both with the county as well as with the OLCC. From a business point of view, and we talked about this last week, and I'll just say it one more time, when you go to large quantities of grows, your quality of product diminishes significantly, and our business goal, stated, written on paper, is to focus on craft cannabis, maintain a higher price point, and have a successful business. And the only way to do that is to be small. So, go ahead.
So, you know, I hear you say that, but we've been, since 1988, we've been the home of craft breweries. And every one of them that could grow, grew. None of them have decided we'll stay at this many bottles a year because that's what it takes. So it's kind of counterintuitive to me in business that if you had something, I mean, we've watched other industries, Hum Kombucha grew up here, became a huge, company. I mean, so if you really had some specialty item that was very popular, it just doesn't make business sense that you wouldn't grow it. So I hear you saying that, but that's my concern, and it has to do with this concern of, I'm not trying to limit your grow. I'm just saying that if you're good at it and it's popular, you'll want to, and you make money doing it, you'll want to sell more. So it seems like that's
again, we have a goal and a stated strategy. I could speak to a little bit because I enjoy craft beer, and there are some craft breweries that have been very controlled in their grow. But more specifically, I've been a wine aficionado for many more years, and there are many, many wineries in the wine industry. Sin Qua Non, I could go through a whole list that have stayed very, very small. They have their vineyard that they control, that piece of real estate, and you can only get X amount of wine out of it, and that's over 15, 20 years. That's it. They've never gone beyond that. To give you a little more insight, we're capitalists, and we do want to make money. Part of our strategy is we're successful here, and we create our brand because of the quality. We'll go to another state and do another 5,000 square foot tier mature canopy, and that's how we will grow our business. Trying to grow by volume within Oregon now and for the foreseeable future is a fool's errand because everyone knows how much oversupply there is of generic quality marijuana. That's a losing business proposition for us to try and go into that. So in closing, I ask the Commission to focus on the facts and standards as has been presented by county staff and their approved administrative decision. We have met the county standard in all applicable sections of the burden of proof. Particularly regarding youth activity centers, the county staff is very detailed in their findings. Conjecture about what could go wrong is not sufficient for the commissioners to deny an application. We look forward to setting an example as a model craft cannabis business for the county and the state. We also look forward to being a positive addition to the McKenzie Canyon community. Thank you.
questions.
Are we going to be getting a letter from your electric company then? Because you're telling us that the easement was grandfathered in. They're going to write a letter directing that?
I can ask them.
Okay.
to do that. We've had many conversations on the property with them, and they were quite embarrassed that they didn't do their work right the first time. But
Okay, so
we
they'll
will
be
ask.
getting a letter. And do you happen to know when the nesting period is? How long of a nesting period is for the golden?
I don't have it right here in front of me, but it was in Emily Wiedner's letter.
Okay.
That she entered into the record last Monday, and
Okay, so you don't
I
remember.
don't have it at the tip of my tongue, but it's documented there.
Okay, so,
So just, yeah, right, is that-
yes.
Can you provide just a little scenario about what the growing season looks like? So if there's not residential on the property, if somebody's going to show up during the day, check on the facility multiple times, would there be more than one person? Just kind of the scenario of what it looks like for a growing season.
Yeah, so being the head cultivator, I'll be out there before sun up and won't be leaving until well after probably sundown. 2, maybe 3 people working with me side by side the whole time. Pretty much Monday, 7 days a week, 365 days. There'll be someone there, you know, at least 10, maybe even upwards of 12, 14 hours a day. You know, just making sure everything's running right and everything's on point.
And to clarify, that's when we're fully operational. As we said, because of the power issues, we're starting slow, greenhouses, dependent on the sun, so much more limited.
Yep. Well, and then do you plan, so it's the irrigation and growing season basically, and then it'll be quiet for a winter season and off season?
Yes, initially, yeah.
Yep.
I thought you said 365 days a year, so what are you doing?
Well,
When we're in full operation.
when we're in full operation, that's, I took it as he was asking for what was going on full operation. So right off the,
Because, I wasn't listening to the 365. I was thinking you've committed to the irrigation season, so you think you'll have water throughout the year, you're going to ship water in?
so to
winter,
begin,
possibly in the
what'll
future.
end up happening will be just during the actual growing season with the greenhouse because of the power constraints. As we work through that issue and as we're successful with retail sales, then the farm will actually start building from there and growing. Obviously, once we get those power needs dealt with CEC, once we can bring in more power. That's how we grow the actual farm. So it's baby steps. It's starting small, making sure that we get our niche back into the community after my medical days, and then slowly but surely over time start building up to our potential 4,960 square feet of flowering canopy space.
But then also growing past a single season crop into a year-round operation, is that?
Yes, but
the vision?
I mean, we're probably talking 2 years down the road, and that's just a guesstimate off the top of my head. I have no clue how or what the time frame is with CEC, with them upgrading the substation, so.
And you just had mentioned about trucking in water. Again, we've been in touch with Three Sisters Irrigation District and now the Oregon State Water Resources Office, Water Rights Department, and they are indicating, and we're following up to get it in writing from them, that we can store the irrigation canal water, so there's no intention or expectation that we're have big trucks full of water coming down the road. We're going to pump water into cisterns and in the long term and use that for the months that the irrigation canal is not operational.
So you use the word pump, but you mean utilize the pressurized water from the irrigation district?
Yes.
Making sure we're clear.
Yes.
Sorry.
And
I
then,
don't think that's what they're saying. I think they're saying they're going to get water out of the irrigation or pipe during the
When it's
piping season, and then they'll put it in a cistern, and they'll pump it out of the cistern to.
The cisterns will be
Gravity.
above, it'll be a gravity
Oh, yeah,
fed
that pump side.
situation.
So the-
So the whole purpose of this farm is to be eco-friendly. We're not using the traditional HID lights that are such power-hungry light sources that you see a lot of these farms use. We're actually using LEDs. So with this upgrade, we're looking into as much renewable energy and as much green energy as possible to be efficient, to not have that carbon footprint, and to minimize the power consumption of a cannabis farm.
that's it?
So can I,
Yep.
I'm actually looking at the letter from August 30th of last year from Emily, who works for the U.S. Fish and Wildlife Services, and she said bald and golden eagles are protected under both the Migratory Bird Treaty Act and the Bald and Golden Eagle Protected Act. And the bottom paragraph says, we would appreciate updates on this project and whether or not the applicant is capable of avoiding disturbance during the nesting season, and that nesting season is from January 1st to August 31st. Now, how's your filter system going to work?
What kind of filter system?
I mean, what kind of filter system are you using?
Can you be more specific?
Well, no, are you using a carbon system so that we don't have a lot of noise going on? I mean, I'm just wondering about
For what, the indoor or the greenhouses?
the indoor, so that, to keep the odor in.
So the indoor is a fully contained system that keeps everything inside. We're sealing everything up. The bypass that comes off that will heat the radiant heat floor that will help heat the floor so we're not using as much electricity for the HVAC unit during the winter or summer months. As far as exhausting it outside, there is none. It's all kept
It's going to be
self-contained inside.
Okay,
So
all right.
I would refer the commissioners to our burden of proof, which includes the certified report from the mechanical engineer, I hope I'm getting the title right, that covered noise, odor, et cetera. And then if you look at the most recent letter from Emily, she specifically talks about its construction noise during that period as well. I haven't been able to track down an actual direct phone number to her. On the letter, it was cut off. It just had part of her title. But I'm working to establish direct communication with her so that we can keep her updated as well and address any questions and concerns she may have.
So a couple follow-ups on the Golden Eagle nests, and I think it's the first grower we've had, that was a factor, or we've considered it, so we'll have to review everything in the record, but it doesn't seem like there's an absolute ban of any activity, but there's this restriction of what kinds of activities. So if the nesting period is January to August, so if you were to get a permit, you couldn't, under that, these are pretty close apparently to where the nesting is. So you said, I think in your testimony today, you wouldn't build anything between January and August 31st, so you'd basically have next fall up to December. I mean, you have 4 months basically to build what you're building.
Which initially is going to be 1 or 2 greenhouses.
Well, I'm sure there'll be other activities you're doing there and stuff. So did you ever give any thought to moving this now that you've heard about the Golden Eagles further? I mean, your property's big enough, you can get further away, putting in a different portion of your property.
It's certainly possible that we could put stuff down on the valley floor where there's hay. I'm not sure. I think that would probably open the door to the appellant, because I think I've been a witness not a witness, but in the audience in other land use hearings where people have made that a big issue. You're taking away valley floor farmland and putting buildings up on it. If the county wanted to propose an alternative to us that is within their realm to approve, we would certainly be open to having that discussion.
Okay, that's something to think about. As in terms of your farming, if you have a building that is this much and it's on a farm, say it's on a farm, a currently farmed acre, and you're doing farming, it may change the way you have to farm your hay, but it wouldn't necessarily mean you're not farming. So it's not in our code, it's not a direct preclusion. You're not precluded from putting it on that kind of land. There's been certain applicants that have come to us that said, well, we're doing this to protect the farmland, and that they wanted to change the setbacks over that. But But we haven't ever said you can't put it on existing farmland, so I don't think that's the rule, so.
So we're certainly open to doing that. You know, one of the driving things of putting it up off of the valley floor was because we wanted to blend in to the neighborhood and not be an eyesore. So
Again, it's
like,
come out because of the Golden Eagle.
yeah,
Right.
Yeah. And-
yeah.
The other-
Right above the pipeline, there's a bunch of trees. I mean, the whole purpose was to keep that farmland open so we can continue to farm that and put, if you will, right along here are a bunch of trees, because that's where we were gonna put the greenhouses, we're right over on that side. So having a bunch of the trees and adding a little bit more low-lying shrubbery will help break that up and won't be such an eyesore, one, and two, what little noise that does come from that will also help get broken up by those trees and shrubs.
Yeah, and all things being equal, in other applications, that would be a preferable probably position, but there are these other issues. The other thing I want to say is with the water rights, I mean, you're making statements about what the Three Sisters districts told you and what Oregon Water Resources has told you, and we've had a lot of hearings now, and we've had information from those groups themselves. Our understanding of the water rights allowed to your marijuana grow is the amount of water that you would get for that footprint. And so, and you have it for the 6 months that you have the irrigation season, unless the irrigation season runs out. So you can't store an acre's worth of water rights for this, several, thousand, half acre, quarter acre worth of building. So I don't know how you've done your calculations with storage, but you can't just like take all these water rights from your fields down below and store it all up for this one building. You have only so much storage rights. So I don't know whether that you can store enough in the 6 months irrigation season to then water all of the, I'm just saying that's what we know, and we'll probably be looking at what you prove, not just, he said, and then.
We've gone through the calculations. I'm not sure if that actually was part of the land use application, but we have supplied all of that as part of our OLCC application. And we're using drip systems, and it's a fraction of the equivalent space, for the water that half acre or acre equivalent of hay, we're using a fraction of that for our cultivation.
Then my last question is on the power. You wrote here that CEC has informed applicant that they own protecting our power access due to the fact that they neglected to acquire an easement. So are they planning to give you another easement, or when that they own it, it doesn't really tell me what much.
On multiple occasions where they were out the property with us, Ted and other folks were there, so we have not just one person's ears hearing this. They were very clear that they didn't do it right, document when the power and the properties were subdivided, and that, because we were concerned, and we're asking them very pointedly, Mr. Calavan says he's going to tear the power out of here. And they said, no, you do not have to worry about that. We will protect you. They went and did research and came back and said, as long as you don't add to the capacity of that current line, we got your back. We're going to take care of you. And that was a very fundamental decision, and us continuing to move forward with the property. Them making that statement, and then we have discussed with them future alternative solutions on how power can get properly brought to the property to upgrade it for our long-term full capacity.
Okay. Thank you. Any further questions?
No.
All right, thank you both.
Thank you. Thank you.
So, let's see. there anyone else that wanted to, well, I guess that ends the rebuttal, and so there isn't an opening for any further oral testimony. So now we proceed to discuss our next steps.
So with the conclusion of oral testimony, now the board has the discretion to consider leaving the written record open for a time period for additional written testimony to be submitted. I believe last Wednesday there was a request from the appellant's attorney to do such that. So here to establish that time frame.
So at this point, in a hearing like this, we decide whether we're going to I would be in favor of closing the oral testimony today. And then we would discuss whether we're going to keep open the written testimony. We typically do this 7 days for written. Anybody can put anything in, and 7 days for rebuttal of that, anything that came in, and then the 7 days for the final argument by the applicant. So that sounds good to me.
Yeah, I support closing the oral testimony in 7.
I'm waiting for 2 letters, so yes.
Yeah. So I'd be supportive of that. Do we need a motion then to approve that?
No, if that's the direction of the board, that'll be
Okay.
clear.
And just as, I'm not sure who would supply what, but there are some things that we haven't really been fully informed on, in my opinion. So, one has to do with the 4-H activities, and if there's people that have them and neighbors that have those, I think the record's somewhat weak on that. I also think there's some lack of clarity in some of the electrical and the water issues. And I still have some questions a little bit about the Golden Eagle, how that affects our decision-making. But so those are, if someone's involved in this on either side, those are things I see that are still questions.
Generally,
Yeah.
no, the hearing's closed, but if the chair wants to allow a kind of a general procedural question.
Yeah, I guess if you have a procedural question, that'd be fine.
Maybe come join us in the.
You want to come up and join us up here, restage?
Brought to my attention that water being a very tricky subject, the written plan for where your water is delivered to your property has to match the actual field. So if they're talking about using irrigation water someplace other than that field, I have not heard that water transfer papers have been filled out. I have not heard today that the ducks are in order. And my question is it your job to make sure that that's happening? Is this back to compliance that I talked about, where there's this huge gap?
Well, you're raising an issue that really wasn't raised by any of the testimony, but is an issue raised sometimes in water rights, that you have a certain number of water rights for a property, and they're specific to a certain part of the land parcel.
You can
You're going to
change
move,
that,
but you
but
can
I've not
change
heard-
that. But I
I
don't
have
know.
not heard that
I don't know if
was
there's anything in the record about there's been an application to change it to a different location. I don't know that. And
Well, enforcement of water and those water rights is the irrigation district's responsibility. So,
Oh, well, I was at a meeting and Mark Thalacker said it's our job to deliver the water, period.
well, yeah, and I think it's a little bit
I
of
don't know.
both.
That, I was at a meeting and that's what I heard with my own little ears.
But I do think, well, it's probably the Water Resources Department also, I guess, would be, I don't know what's in the record that we haven't had testimony on about, but that can be an issue with water right use, is whether or not has been transferred to the parcel. Imagine this isn't a marijuana grow and you want to plant hay over here and you have water rights water rights are specific to an area, is what you're saying, and
There's a paper
you want to
trail.
transfer, yeah.
And it's
I don't know
not
that.
impossible. It's just, it has to be done. And I have not heard today that specifically was addressed
And
and
per our notes from Liz Dixon, it says she has a letter from Three Sisters saying that they have 8 acres of water for tax lot 100, and it's a form letter, so we asked for a clarification from them from Three Sisters.
Thank you.
We did ask for that.
Okay.
I would suggest, since that's straight from procedure, to
Yeah.
give the applicant a further opportunity to rebut just
Yeah.
that.
Yeah,
If you want to say something
would you like
real
to
quick,
say
it's
something?
what the offering was.
Just to that issue.
Yeah, well, to that issue, I guess, number one, I would say, don't include it in the record because it was outside of testimony being closed. And
I think that ship sailed. It's in the record.
if
you
it's
wanna
in the
rebut it,
record,
now's the time to
then
rebut.
I would just say we are a legitimate business. We're following the rules. We're in touch with the water district, and we understand the point that was raised. And we believe that we have a solution in place that will make us compliant.
Great, thank you.
and
Thank
so, and then we'll review what our ordinances require us to do is not, we aren't the water right signer off or entity. We're looking at whether our ordinance is met with regard to what we've learned about water rights. So that'll be probably the scope of what we're doing, but we'll see. Okay, so we'll go ahead and close, or we'll extend the written testimony for 7, and then you want to walk us through those dates and.
Yes, absolutely. So the initial 7-day time period for any new testimony is open until 5 p.m. on March 20th. Following that would be rebuttal to any information in the record, and that will close at 5 p.m. on March 27th. And then applicants' final arguments are due by 5 p.m. on April 3rd. I ask that any new testimony be submitted directly to me as staff. Matthew Martin, my cards are on the table on the side of the room. They can be submitted either in person, via mail, or email. And I do ask that you reference the subject property or the project file.
Okay. And with regard to our timelines, you have a disclaimer or whatever you give about they need to do it before exactly 5 o'clock because it has to get to you by 5 o'clock.
Correct. Yeah, the 5 p.m. deadline is receipt at Planning Division offices. So that would be either in person prior to the close of business at 5. Also acknowledging that if you're sending electronic mail, there can be a bit of a delay in cyberspace. So I proceed with caution there and provide yourself ample time to, once you hit send, for that to be received at our offices by 5 p.m.
Adam, any questions? Or
Adam Smith, Assistant Legal Counsel. I just wanted to inform the commissioners, I just checked in with the applicant and they consent to the 777 extended written record period. That consent's important for us to put on the record just for calculating final deadlines, as the board knows.
Okay, good.
Thank you.
So do we have anything else left to do then with this? Okay, so thank you all that came for this and gave testimony, and we'll move on to our next matter. Let's see, shift all our paperwork. Is this yours or mine?
No, that's yours.
Okay. So the next item on the agenda is public hearing on the appeal of a marijuana retail approval at 19855 8th Street, Bend, which is in Tumalo. We'll start out with our staff. Let's see. This is the time and the place set for the hearing on land use file 247-19-000141-A, an appeal of files 247-18-000-546-SP/811-MA. And then staff will outline the hearing procedure that will be followed.
Thank you, Chair Henderson. The hearings body, the Board of County Commissioners in this case, will take testimony and receive written evidence concerning an application from Mike Hayes of H2D2 Properties LLC to establish marijuana retail at 19855 8th Street, Bend. All testimony shall be directed at the hearings body. At the conclusion of this hearing, the hearings body will deliberate towards a decision or continue the hearing or deliberations to a date and time certain. The hearing will proceed as follows. Staff will provide a brief report. The applicant will present its testimony and evidence, followed by the appellant presenting its testimony and evidence. Then, opponents and proponents will present their testimony and evidence, as well as any other interested parties. The applicant, as the party bearing the burden of proof, will then be afforded the opportunity to present rebuttal testimony. If requested by the board, staff will provide closing comments. A full written version of the hearing procedures is provided on the table at the side of the room. Commissioners must disclose any ex parte contact prior hearing observations, biases, or conflicts of interest.
Does any commissioner have anything to disclose? And if so, please state the nature of the same and whether you can proceed.
I have nothing to disclose.
Just a work session on the topic. I know where the property is. So when I drive by, I take an extra look at it currently, but no other connections to the applicant.
Yeah. And I have the same experience with this particular application, the work session, and read the materials that have been provided. I am familiar with the appellant and had represented him in prior legal things many years ago. Not any discussions with him about this particular retail establishment or application. So and had no discussions with that. So I have no ex parte contact. Does any party wish to challenge any commissioner member of the hearings body based on ex parte contacts, biases, or conflicts? Okay. So then, hearing none, then we'll go ahead and open the hearing. And staff, Matt, you'll proceed to give a brief staff report.
Thank you. Again, what's before you is a proposed conditional use and site plan review to establish marijuana retailing on the subject property, as identified on the map to my left. What's proposed is a total operation of just over 1,500 square feet of building area, including 1,375 square feet of new construction on the property. Also included are the associated vehicular and pedestrian improvements associated with the site plan development. I want to note that the application originally included the provision of a food cart and farmer's market as part of the proposal. The applicant, during the review process, removed those aspects of the proposal, so what remains is solely marijuana retailing at the property. The operating characteristics of the use, as specified by the applicant, would include both delivery and on-site sales of marijuana. Review history briefly. This was referred directly to a hearings officer based on the details of the application as well as testimony provided during the notice period. That was on November 29th of last year. The hearings officer issued an approval of the application on January 29th of this year, and then a timely appeal was filed on February 7th. Shortly thereafter, the board issued an order agreeing to hear the appeal, which brings us here today. So similar to the map in the room on the monitors is a general vicinity zoning map showing the properties located in the Tumalo Commercial District. To the east is Tumalo Residential District. To the south, surface mine associated with the Hooker Creek, a knife riffer operation. I want to make sure we get that clear. As well as Tumalo Industrial further south, and then into the agricultural lands in the periphery. Subject property located near the intersection of Highway 20 and Cook Avenue. It does not have direct access. Well, it has frontage on Highway 20, does not have direct access, so that access is provided across the property to the north via an access easement identified on the image on the screens. Existing development includes a a food cart pod of several food carts and interior circulation pattern and associated parking and landscaping. That's important because much of that existing parking, circulation area, landscaping will be retained if approved. So I recognize the detail of the image on the screens is limited. I just wanted to identify the layout of the property as well as the details of the proposal. Here's a zoom in of the actual structures to be improved. Existing is a structure on the east side that's to be used as a ADA accessible restroom. On the north side, bicycle storage space on the south side. New construction is retail space along the western portion of the property, and then a storage room, secure room along the eastern side. Those two connected by interior access. As identified in the notice of appeal, in summary, the appeal objects to or identifies or questions adequacy of and legal right to access to the property via that access easement. Questions the compliance with separation distance from schools, state park, and youth activity centers. Compatibility with existing or projected uses on surrounding properties. The required condition of approval to widen the driveway access across the property to the north, which is located within that access easement. Adequacy of the traffic study and analysis that was provided. Compliance with the requirements of the Federal Controlled Substance Acts and the doctrine of federal preemption. And then lastly, risk and liability of the subject application places on the appellant, the owner of that property adjacent to the north where the access easement is located. The conclusion to testimony, similar to before, the board has options to either continue the public hearing to another date certain, close the public hearing and leave the written record open, or close the written record and the oral and written record today and commence deliberations. And available for any questions now or later.
Any questions? What's that?
Later.
Later.
Thank you.
So this would be the time for the applicant to present their testimony. You could come up and identify yourself for the record. I'm not sure how many people are going to testify. By the way, if you're here to testify and haven't already filled out a blue form, you need to fill one out. They're over here at the table, and give those to Sharon over here. So there's we have quite a few. Looks like planning to testify on these. So we kind of have some flexibility with timing. Looks like there's a lot of interest in this, and there's kind of some complex legal issues. If you can make your testimony within, I guess our target would be 20 minutes, but I know that the appellant had also provided a PowerPoint they want to present that may take up to 30 minutes. So we'll try to do that. So we have more meetings this afternoon, so we need to get this hearing done to go on to the rest of our meetings too. So hopefully you can make it within that time. So welcome.
Good morning. Thank you, everyone. My name is Stephanie Marshall, and I'm an attorney representing the applicant here, Mr. Hayes with H2D2, and wanted to thank you all for your time and attention to the public hearing today. I do share your concerns, Commissioner Henderson, about the time limitations. There are some complex issues in this matter. We want to make sure that we can cover those completely without feeling rushed and without being constrained by time. So to the extent that we need to talk about the record being left open or continuing the hearing to another date to continue presentation on this matter, then I think that we can be open to discussing that. So again, I have Mr. Hayes with me today. I have Amanda LaBelle with my office. She's operating the PowerPoint, and we do have several members here of the public and supporting the application that have all put in blue sheets with you
Good.
guys. So,
You know, and the legal arguments, you know, a lot of this is gathering factual information. So the primary thing today is to get our factual things. You've briefed some of the legal arguments pretty thoroughly, and I know the appellant has also. So we can always get more. Typically, we would leave the record open for additional on that if, after the oral testimony. But
Right.
we'd like to get as much of the facts out, and we've got a lot of people here that want to testify on that. So
Correct. And we have an interest in getting those facts to you. As you mentioned, you know, we've submitted several letters to Mr. Martin, for the record, that go through those legal arguments in quite some detail. Don't want to, I don't want to say bore you, but you know, I understand that the purpose of the hearing, of course, is to get the facts before you. That's a little bit more interesting, I think, for the members of the public as well. So with that being said, let's go ahead and start with our slideshow here and the PowerPoint presentation. Staff just went over some of the key aspects of the proposal, which is the square footage is put up there, plus a bathroom for a total square footage of just over 1,500 with the parking spaces. It's accessed via a 30-foot easement for ingress and egress, which has been used for commercial purposes for the last 3 years, coming up on 4 years. The site is currently approved for another commercial use, and the access easement has been used for that purpose already. It is an existing 30-foot easement. The hearings officer, in his decision, talked about the facial validity of that easement. You've got the easement that's signed, recorded, and it's for ingress and egress. There's no restrictions on use. That's more of the legal argument, but that's also set forth in our materials. The purpose of the application is to service cannabis to the county through delivery, as well as on-site retail. The delivery aspect is independently regulated through OLCC, though just like the county, it's considered a component of retail. There's no separate delivery license you have to get with the OLCC, just like there's no separate delivery permit that you have to get with the county. So we've provided information on that to let the county know kind of what's going on here, but it's not independently regulated or restricted. So if we can go to the next slide. This is a picture of the site plan, and the elevation meets the county code requirements. Mr. Martin had up earlier another image that shows the access, the circulation, and the parking. I will have Mr. Hayes kind of go into that in more detail. We'll probably circle back to that slide, but if we can advance to the next one, that actually talks about the retail component of delivery. And I believe that I've probably put into the record, if not before, in these proceedings before the hearings officer, the vast regulations that there are by the OLCC that restrict, you know, the delivery component. We aren't going to have a vehicle that's branded. You aren't going to be seen, you know, it's not going to be like Domino's Pizza, you know, going on and off site, you know, and there are restrictions on the number of the amount of the value of the marijuana that can be transported, the address, and the delivery, the purchasers to whom delivery can be made. Again, that's kind of really drills down with a lot of facts that's already in the record in my letters, both to the hearings officer and to you in the record on this question. But as we go through all of this, we're happy to answer questions on that part of the retail component. All right, so moving right along to the next couple of slides, I'm going to turn it over to Mr. Hayes to give you a background on his proposal and his involvement in the community as a businessman and as a community resident.
Thank you. Thank you, Commissioners. First, I think some of you recognize me. I've been in front of you before and has testified for other cannabis topics. I come in front of you again today as a member of the community since 1972. I was a captain in the Marine Corps. I have an MBA with a background in finance and a minor in economics. And the reason why I get into that because this topic is sensitive and the public needs to know who the applicant is. And I think that's important that to be known that I'm not an outsider. I'm an insider. My children went to Tumalo Middle School. I currently have owned businesses in Tumalo, in Redmond, and in Bend. So I'm very familiar with the ongoings of all three of those areas. I currently own Mavericks Country Bar and Miracle Greens Dispensary and Miracle Farms in Tumalo. But most important, what we need to talk about is Miracle Greens, because it's not the what if, it's what has been with them. That company is committed to the high standards that I am as an adult, and a handshake to you as county commissioners, that we give back to the community and we do it better. We do it better than any other business because that's what I promised you. We do it to such a degree that the Bend Bulletin actually did an article on us last year about our company, not because we're a dispensary, but because our company is giving back to the community from ground zero. Next slide. So what is Miracle Greens? What will come to Tumalo? Award-winning dispensary. The Bulletin gave us a number one. The Source awarded our employees for customer service. We passed all minor decoys from OLCC, so we're under that. OLCC loves us. I've been dealing with OLCC for 14 years now, and I have, coming from a military background, you work with law enforcement. You don't fight with them. You're very transparent. It helps them and it helps you. From the pictures up there, you can see there is no cannabis logos on my storefront. There's no minor attraction. It's clean and professional. There's actually a steel vault that surrounds the secure area, as well as vaults inside of the vaults for reasons that are to upkeep the integrity of the cannabis. Next slide. But really, why you say to yourselves, why do we need another retail location? And I'm going to give it to you. And I'm going to give it to you because there are people in here that are anti-cannabis and pro-cannabis but support this measure. And the reason why they support it is because right now you have an invisible cloak over your county that supports the 646 medical farms that are thriving because we cannot reach out to the county itself. And so if you look up that slide, what you see is 25 retailers within city limits that are not allowed to deliver outside of those city limits. You have 1,800 plus patients that require cannabis, and there are 646 farms that are medical only, and only 34 recreational farms. Next slide. So what does that show? Go ahead.
Did you happen to turn this PowerPoint in as an exhibit, or?
Yes.
So did we get that, or? Okay.
So what you see in color there is where the retail locations right now can deliver to. That's it. The rest that's in white is supported by your medical farms. Next slide. So with this proposal, now you as county commissioners will have a tool to say to your constituents, hey, we can reduce the medical farms. It's not necessary anymore to have 646 farms. Let's support the 34 recreational farms out there because Miracle Greens in Tumalo can deliver to all parts of the county. And that's, go ahead.
So there's a regulation that all of the dispensaries in the city of Bend can't deliver outside the city limits? Is that what you're saying?
That's correct. And same with Lapine as well.
And we do have, isn't there a dispensary Sun River?
Yes, and it's Cannabis Nation, and they do not, or have it signed up to deliver. So you have zero ability to deliver in the county. So what does that give you as a county? It gives you reduction in water if you're reducing medical farms, gives you reduction in the farms themselves, increases your county tax, increases local law oversight, and local safety. Because I will tell you right now, and it was pointed out earlier this morning that those medical farms are not being oversought. There's only 3% have been inspected. So we as recreational farms and retail shops are highly regulated to the point where we can tell you we're the only, people call it a crop, some people won't call it a crop, we're the only crop in the United States where you can see from seed to end user. There's no other crop. More people were killed by cucumbers last year than cannabis. I can tell you that if there's a problem with 1 gram of cannabis, I can tell you what street the driver turned on to get to my retail location. I absolutely know everything about it. Very, very safe. Medical market, it's not. Nobody's overseeing it. So the reason why I bring that up.
But you bring that up, and that's great that maybe you can in yours, but I mean, we've had cases already in Deschutes County where legitimate authorized growers have diverted, I can think of the one involving the hash oil explosion, which came from a regulated recreational grow, ended up at a hash oil house that exploded. So theoretically, the system exists that you can track everything, but that hasn't been exactly happening. Is that fair? I mean,
that's not fair, and I'll tell you that you can track it. So to your point there's always going to be bad apples, and OLCC commissioners, I listen to the audio tapes every month, they have stated over and over and over again, it is a privilege to have a license, not a right. So the moment that you are a bad apple, that is getting stripped from you. And a lot of people are saying, well, what if your canopy goes over a certain size? Call the OLCC, have them come and measure. They are not playing around anymore, and they will take it away from you. And it's only retailers and growers like myself that hold those high standards are going to be the ones that are going to be around long term. So that should take away your fear. And it is controlled to a certain extent. If they're doing something illegal, I will also push this as an argument. Most of the growers that are doing illegal stuff are probably being pushed into that market because there are 646 farms they're competing with that don't have to pay taxes, don't have to abide by the same standards. That's pretty tough. Let's get into the beer business, because I'm a beer guy. That would be like me having Mavericks and then 2 bars on both sides of me don't have to pay taxes and can do whatever they want. I wouldn't put up with that as a small business owner, and that's what I'm saying as a recreational guy. This is a tool for us to shrink what is going on in that black market. There are, and do you want to speak to Tim, or I will?
Sure, and I'll weigh in too. Stephanie Marshall again. I can provide the commission in the record copies of the applicable OLCC regulations. There are, thousands of the regulations. I mean, they start at OAR 845, 7000 on are the cannabis tracking system regulations, the plants that have to be tagged, the requirements that OLCC has adopted in this regard. There are going to be bad apples, but I guess I'm going to ask the commission as to whether they're going to operate from the presumption of guilty, not innocent. We're here before you trying to comply with all the laws. If we're going to be infected by somebody else in the industry that has not complied with that, and then there's going to be a presumption against us that we're not going to comply with those regulations and risk losing our own license, risk losing our own land use approval. That's a tough road to hoe. That's an uphill battle that I don't know if those same questions are being presented to other farmers of other crops or other retailers of other businesses. It's a really tough burden for us to bear just because we happen to be in the marijuana industry. And I do question whether that's fair. But if you want to continue on that topic as well.
We've had the OLCC director in front of us to talk about what they do and what they can do and what the regulations. So and the big issue's really been is they have a lack of personnel to do a lot of the things they need to do, and so that and they'll admit that, and they've admitted it in meetings we've been at. So the system could theoretically track everything and could, but we're aware that that's not always happening, and that's all my point is, that it isn't a safe or full safe or whatever is I guess she was maintaining, and we've had experiences in our county with that, so that's all I'm saying.
The only thing I'd add to that.
I'm not saying you couldn't do it.
No, the only thing I would add to that, Commissioner, is it's better to be able to see it than not see it, and right now you guys aren't seeing it. And that's what you get from a retail shop is the deputy who has contacted me personally to help him understand how to address the medical market is he has the visibility, right? He could come into the shop at any time and see what's going on. But when you're dealing with the medical market, he has no visibility. It's a nightmare for him. And so I'd much rather see the mouse scurrying around the room than laying mouse traps out. And let's just, at this point, you need to see what's going on. And that's what this retail shop, this application is going to provide you. I will also point out that the anti-cannabis people in support of this are Tim McGinnis and also Bill McCormick, who was the former ambassador to New Zealand. They both are Tumalo residents. They understand what I'm doing. They understand my integrity and the moral courage that I have to stand up here and be the guy in no man's land, right? I'm the guy that's saying, hey, there's some bad things going on in the cannabis industry, and here's a tool to fix it for you.
Great, thank you. Next slide, please. We're going to jump in now to the applicable standards. This is some of the legal stuff that we don't need to dwell on because it's all on the record and in my written submissions. But the bottom line is that the county has decided to allow marijuana dispensaries subject to the criteria under the supplementary provisions in 18.116 and under site plan review and conditional use review. So, understand the commissioner's concerns and, having to answer to their constituents, but the county has opted in, and, you can't give with one hand and take away from the other. So you've got dispensaries as a conditional use in the Tumalo Commercial District. And as long as we're meeting all standards, which we submit we are, your role is not to essentially take away what has been allowed. Going on to the next slide here. So there are so many considerations that I know that you all hear as commissioners: overproduction of marijuana, too many dispensaries, federal law prohibitions, personal beliefs on cannabis. Fears associated with that, with respect to minors and the black market, increased calls for service and crime. Next slide. And then, along those lines, there could be a concern on the commissioners, from your viewpoint as to the product that's being sold. We've also got the easement that I brought up earlier, and speculation as to the impact of allowing this use on this property, what that's going to do to the adjoining property owner. I'm not diminishing the fact that these fears and concerns exist, but we also do have facts that are before you, and we can't have you deciding the matter based on speculation or fears or concerns. There has to be some real evidence and the standards that are before you. With respect to unspecified quality of life impacts, the commissioners sit as a legislative body, but then here, you're a quasi-judicial body. You get to apply the standards that are in the code. If there's going to be revision of those standards or different standards to address some of these unspecified impacts, that would be a different type of proceeding. So there we go. The presumption that the owners and the operators of this use should not be that they won't comply with the law. You know, we've got Mr. Hayes here before you with his record and the work that he's done. He's been working on this proposal for 3 years, and he's continuing to modify, consider impacts and items that are called for in the code. So it's definitely been a process that has been deliberate and responsive. So I think that's also something that the commissioners can consider. Next slide. This is a little bit about what I just touched upon. You know, looking at this for several years to carefully consider the site and the use. You know, how can we address as a business owner, you know, what we'd like to have in the area, but also at the same time, you know, that's going to help the county commissioners and the constituents address some of the wild west of the medical grows and market. So you know, I've touched upon how we meet all applicable criteria. The hearings officer has a 59-page decision, and he went through each and every item in this in the code and in the testimony that was presented. I wanted to mention as an aside, I'm also a hearings officer for Deschutes County, and you know, I mean, just stepping out of my role as the applicant's attorney, you know, it was a very impressive analysis, and my hat's off to this hearings officer for doing such a thorough job. I think it helps the commissioners and county council's job a little easier when you've got somebody that's done such a thorough review and analysis. So next slide, please. We'll have Mr. Hayes go back to him, kind of going through the citing of this proposal and the surrounding property owners.
Sure. So with the lack of time, I'm going to go through this pretty briefly. We know where the site location is. It's bordered east by commercial properties. Next slide. By the west, Cook Avenue, and south, Highway 20. Next slide. The proposal design concept is what you see there. That's the building. That's what it would look like going into the site.
We've got the PowerPoint now.
Yes.
Oh, all right.
Fantastic.
All right.
Hard for me to read the.
Yeah.
Yeah.
All right. Have you go through it? Do you want to do the next one? I can.
Okay. The next slide. Okay. Next slide here. Compared with the existing commercial use of the property, which again is accessed via that access easement that's broadly stated for ingress and egress, we've got a number of things that are going to get better. There's not going to be as much gray water and brown water produced because you're not going to have those food carts. The number of employees on site are reduced from 5 to 2. The traffic will be reduced as well. The exterior appearance will now kind of blend in with the surrounding area and upgrade the appearance of the site. A couple of the commissioners mentioned that they're familiar with the site. They drive by it. They kind of check it out. You know, the photos that we have in the next slide will show a little bit of that. And the entrance on the south side to the building itself won't face Tumalo, so it's not going to be observable by residents. And then I also wanted to touch very briefly on the request to exceed the front yard setback. So we're going to have a greater setback than under the code, and that's because it's going to match what's going on the actual site itself. The adjacent property is not developed, so there's nothing for it to line up with, which is kind of the purpose of having a maximum of 15 feet setback. So because there's no purpose that would be served for, you know, holding us to the maximum of 15 feet, that's already been recognized by the county in its prior food cart approval. Okay, next slide, please. Go ahead, Mike.
So boots on the ground, the design application matches what we're seeing developed in Tumalo. I put in 3 different pictures of the Bite, the coffee shop, and the landscaping company, and the building matches what is going on by There's also a cider company that's currently building on the area as well, versus what has been there since I was a child. Some of the older buildings, love them, but eventually they will be developed and made to come up to speed. And as we all know, some of those buildings, like the Mexican restaurant, can't even open because of the septic system. So there's development is needed, and so boots on the ground.
Okay, I think we're going to kind of almost essentially skip the next few slides because I've touched upon it, and Mike and I have touched upon it. So the setback, and then the OLCC regulations in that slide, and then I think Mike also touched upon the fact that we've got a public access section of the store and a secure section. It's going to be a vault that's rated consistent with the OAR OLCC regulations. And then I think also Mike touched upon the marketing and public signage won't reference cannabis. I've already touched upon the next slide, which is assumptions that are not supported by evidence. There might be some concerns that come out, but without hard evidence to support those fears, the county has no basis to make a decision on those factors. Okay, Mike, we're going to turn it back to you on the retail misinformation, please.
So one of the things I did as a community member is I actually walked to these businesses and I said, what are your fears of having a retail shop? And a lot of people, well, I know that's going to bring about bad apples into our neighborhood. It's going to bring crime and so forth. So as a prior owner of Tumalo Tavern and a big fan of the Bite, the food court down there, I said to myself, okay, let's look at the 911 calls coming into those two locations, being in Tumalo and being that they both have OLCC licenses, and compare them in the same time frame with Cannabis Nation. I wasn't surprised by Tumalo. It had 35 calls from 2017 to current, anywhere from suicidal to theft of vehicle, DUI. But what I was surprised, and what should surprise you as the county, is the Bite, which is a family-friendly place, has had more calls in that same time period. The 37 calls, which suicidal person, assault, domestic dispute, animal control, criminal mischief, civil problems, theft, harassment, DUI, and that is a food court. And you look at the Cannabis Nation in the same time period, they had 4 calls. Harassment, civil problem, a traffic stop, and lost and found. And I'll tell you why. It's because every criminal knows the moment they step onto our property, they're being recorded. And if you don't believe me, about a month ago, we had a young lady come into our store, and she put her hand into the employee tip jar and took out money. And she left, and the employees saw that they were missing some money, so I went onto the camera system, found her face because of the clarity of the cameras, put it on social media, and we caught her. We did, that's to the standard that I am. I don't know too many bosses that will go to that level for $17, but that's bad behavior that I won't put up with in the county. She returned the money, but more importantly, I made her write an apology letter to my employees. Her dad called me from Arizona thanking me because there's a lot more I could have done with her, but I think we solved the problem and hopefully cured a bad apple in the community. But that's, again, the character to which the application is regarding.
So I just want to ask about your comparison. Cannabis Nation is the dispensary in south of Sun River?
Yes.
But we don't really, I think that went through on a hearings officer, so we really don't know very much about that. I mean, is that the same type of facility, the same, I mean, it's not this kind of building, though, and doesn't have the delivery and all that, does it?
It does not have delivery, but the comparison there wasn't about delivery. It was about the actual what type of actions are taking place on the property. Are police being called to the property? And I looked at the time period from when it was approved to currently. And you could look at my premise, the same, but I wanted to give you something apples to apples, not city of Bend, but county to county.
Okay. Did you have anything else you wanted to add on the 911 stuff, Mike?
No, I don't.
Okay, great. So I've already mentioned the fact that the county commissioners opted in and allowed marijuana uses. There's the Federal Controlled Substances Act is not a basis to prohibit uses that it has made already a decision to allow under the code and state law. Okay, so this is kind of some of the meat of what we want to talk about now. The setbacks and separation distance requirements are met. So the first issue has to do with Oregon Parks and Recreation District and Tumalo State Park. And we've got information from the applicant, which is shown on the next slide, but we don't need to jump to it yet, which confirms through a professional surveyor that it meets the 1,000-foot setback, exceeds it by almost 2 feet. Woo. So it doesn't really matter how much it exceeds it by, but it meets it. So therefore, that it can't be denied on that basis. The appellant had put in information from Thai Engineering, which maybe, they could, may allege that it calls that into question, but that, that map that was prepared by Thai Engineering sets forth its limitations, that it's for informational purposes only, and is not prepared for or to be suitable for legal, engineering, or surveying purposes. It represents only the approximate relative location and measurement from the subject property and the state park's property. So we've got our professional surveyor, and then we've got a map that's limited for its purposes by the appellant. Okay, next slide, please. This is our map. We put that into the record a few weeks ago. So that's there for the commissioners to review and consider in their decision making. The next slide shows that not only do we have the actual 1,000-foot met, but we have Highway 20, which separates the state park from the proposed dispensary. So when you look at the Oregon statutes with respect to schools, when you've got another physical barrier, it says that actually you can cut down that distance from schools. I'm just using that by analogy here. When you've got a physical barrier such as Highway 20, again, that's not apples to apples; it's apples to oranges. But I use that by analogy. So this shows that we've got a real separation, not only meeting the letter of the code, but also the intent of the code. Okay, next slide, please. Now we're going to talk about the Spanish school. It doesn't exist. There's nothing online. You can't register for classes. There's no presence. There's no children. There's nothing, except for speculation. And we really caution the commissioners in their decision making on this basis. The only school that is listed on the Oregon State Department of Education website of their list of all schools in Oregon, and I submitted this in the record as well, is the Tumalo Elementary School, which is 1,755 feet away. Spanish school is not private, it's not public, it doesn't meet the ORS definitions, and it doesn't meet the county code definitions. And the hearings officer went through this in detail and supported his decision making on this. You can look at the actual hearings officer decision in this regard. I can give you the page numbers starting on page 9 of his decision to 10, and then again later in the decision itself. Oh boy. Well, I can put that in later, but it's definitely been reviewed by the hearings officer, and it doesn't exist. It's speculative. The next slide shows that it's not going to even open until September, if at all. We have the registration information. There's no license on record with any of the addresses in the building, and there's no current City of Bend license, and there's even a temporary sign on the door. I think what I wanted to bring to the commissioner's attention also is the fact that this school apparently has had another location also where the appellants, the Gieslers, are the landlord. And information that we've been able to obtain is that The Gieslers raised the rent at that other location in an effort to get them to move, and offered this space is in an effort to kind of manipulate the process here and use that as a basis for the commissioners to hang their hat on for a denial. The underhanded aspect of this scheme is detailed in my letter. It, definitely raises my eyebrows as an attorney, but, I've also mentioned in my materials that when you compare the integrity and the hard work that Mr. Hayes has done here to be above board and comply with all the rules to what is appearing to be the actions by the Gieslers to bring in something that does not qualify as a private school, a public school, and also cannot be considered as a youth activity center. Again, children are not on the site. There are no classes you can register for. There is nothing that falls within what could even be defined as a youth activity center. And the legal arguments, there are more in my letter, where it's not defined by the commissioners. It's a standardless standard.
You've got a lot to cover. You're going on about the integrity of the appellant and things. We'll just look at the facts. If there's as to what activities they are, we'll expect them to present facts to counter that. You're kind of going, and there's a lot of subjective in your testimony about people having fears, and things, and there's integrity, and we're just looking really at the facts of what our ordinances are and what's presented to us by that. So, rather, we're already at 30. I think we're at almost 40 minutes, and you've still got more. So try to keep moving. We get the point. We can read the stuff on.
I appreciate the comments. And at this point, I was actually had moved into the code itself, and the fact that there's no definition of a youth activity center. And that's what I was addressing my comments to, but I don't need to belabor that either. It's in the record. The arguments are on that point. There's really nothing to guide the commissioner's decision making.
Well, you're aware we've made some decisions with regard to youth activities centers, and we have tried to interpret what that means. So there's some, at least at our level, decisions have been made. We don't know whether they'll be appealed or upheld, but. Just so you know, you can say what you want, but.
So I know you're looking for facts. The fact is there's no school there.
Yeah, I think I heard her say that, so yeah.
Right. So, and I'll let my legal arguments stand in the record on that as well, and if the record is left open, certainly once we hear from the appellants, if there are another take on those arguments.
You got about 5 more minutes to finish up your part, and then we'd like to.
Okay, that's fine. Well, I was going to move in this next slide to the traffic impacts, alleged impacts. There is no intersection that will fall below an acceptable level of service under the county's code or its requirements. The Oregon Department of Transportation potential improvements are also speculative. Nothing has been introduced into the record that shows that any particular improvement has been funded, accepted, planned to the level that denial or conditioning the application could be tied to that. So I will just the next few slides are on that issue, so we'll skip through to keep things moving along. On this slide, I did want to mention that the county is assessing over $100,000 in SDCs for this proposal. We do have analysis that's in the record that shows that the traffic will actually be reduced from the existing use of the food carts, but because the county doesn't have a way to determine pass-by trips versus destination trips, that number is actually higher on the record, and we have, we're not at this point challenging that it's a separate decision anyway that the commissioners don't make on SDCs. So, and then to the next slide, I did touch upon the access. The hearings officer's decision in this is very detailed and thorough. The easement exists, it's facially valid. There is access to the property. It's 30-foot wide access, and improvement of the easement for that access is allowed for under the plain terms of the easement document. The next slide. What was that?
Talk to that.
Okay, yeah.
So
let
just
Mr.
for facts here, 2012, and I took some images off of Google Earth, you'll see that there is a hardball going off, which is the access going into the property. 2016, the change of use was committed to this 5 food court, and 24-foot width was required. The developer, and you can see in the image, the developer didn't do what he was supposed to do and only did it to 22.5 feet. So no matter if this change of use was in process, anybody could put in a complaint to the county and say, hey, that's not 24 feet, and it would have to be widened to 24 feet. That was required in 2016.
Great, thanks. All right, next slide. I've touched upon this. It's already being used for access for commercial use. It's just a different type of commercial use. There's no restriction in the easement, again, for the type of use that the easement can be used for. And then, Amanda, please, the next slide, the conditional use permit analysis. That there are factors, and this is legal stuff, so I don't need to belabor this. If you're looking for facts, we meet all the criteria. The hearings officer has found that, and I can direct that. Mike, you had a comment on that as well, or no?
Nope.
Okay, great. And the next slide, the use is suitable.
Is this, I got a question, this conditional use permit analysis, are these the conditions put on by the hearings officer, or are you just saying you're meeting the ordinance?
We are meeting the ordinance. There are 3 factors that the commission has authority to look at to determine whether a conditional use permit should be approved. Site design and operating characteristics, adequacy of transportation access, and natural and physical features of the site. The compatibility analysis is in the site plan review, and the site plan is whether the actual structure itself fits in with the surrounding development. That is a critical distinction, but it is a very technical legal argument, and unless the commissioners have any questions on the facts that support the legal analysis, I think that we can stand on the written submittals on that question.
Agreed.
Okay, hearing none, I'm going to just probably just keep going. The next few slides are repetitive of what I've just summarized and what's in the record. Right here, I mentioned the federal law does not preempt state law, and these points are set forth in our written submissions. I bring it up only because the appellant has made this a big cornerstone of their appeal. And then the next slide, again, no evidence to support denial on the bases that are before the commissioners for the standards. And the next slide, we have insurance. And the slide after that speaks to the Giesler's allegations about they won't be able to obtain loans. And the final slide, the application meets all required standards for site plan and conditional use permit approval. The county can't add new standards via interpretation or hold the applicant to standards not required of other applicants. I again mentioned the hearings officer did an amazing, thorough job in 59 pages, and I think that there is no basis to reverse that decision or otherwise deny the appeal, or excuse me, deny the applications. The appeal itself should be denied. So that's a lot of talking, and I appreciate the Commissioner Henderson keeping me on task to facts. We're here to answer any questions at this time, or we can reserve that for rebuttal.
So I have some questions, but I think I'm going to reserve mine till rebuttal so we can get the appellant's testimony and we
Great.
can hear some more of the people here. Is that okay?
Yes.
Okay.
Thank you so much.
You bet, thank you. All right, so this is the time for the applicant. Come forward and introduce yourself. I mean, the appellant, excuse me, yeah, appellant, yeah.
Here, I got a presentation.
Oh,
for
good,
you.
good. Helps with our eyes.
These are 3 more requests.
Commissioners, Joe Willis, I'm an attorney with Schwab Williamson here in town. My pleasure to be in front of you, an honor. I'll get through this as fast as I can. We do have a slide presentation to help guide. But before I start, Captain Hayes, we're talking about credibility and integrity and so on and so forth. I mean, sir, I'm sorry, but I have to say I'm disappointed in you, because we go back through some of these things that occurred. He is a brilliant, well-educated entrepreneur and very aggressive. And so when I see things that are omitted that should have been put in, I'm sorry, but I can't give him much credit on that regard. And we'll get back to that on a couple of these points. And before I forget it, this is the first I've heard of him getting a surveyor. We challenged him twice to do it. If that's in the record, I want to see it, and I want to see the certified thing, and I want an opportunity to rebut that, because we've not seen it before. He didn't do that. What he did do was send in some slides, and he even omitted the absolute disclaimer that this county puts on the materials that he used. That's not right. And he came up 5 feet over. Well, we'll get back into that, but I'm sorry, sir, but I have to say that. So let's get started quickly. And one issue in this case is what impact does the CSA, the federal law, have on this? It clearly preempts anything that stands in the way of full implementation of the federal law or purpose. And if you don't believe that, you take it up with the Oregon Supreme Court. That is a straight up holding by the Oregon Supreme Court. When the appellant's lawyer somehow persuaded the hearings officer that he couldn't make that determination, she didn't even cite that case or talk about it. I did. And those are not tough legal issues. That's been the law since, the second slide, let me push this here real quick. Whoops, Matt, it's not moving. Oh, there we go. I got it, thanks. But that's that first slide there. That was the Emerald Steel Fabricators. That was a medical marijuana case where a person had a medical card authorized by state law to use marijuana. And he couldn't pass the P test, and he got fired. And the Oregon Supreme Court unanimously said it's preempted. And because you cannot have, and I'll go to the next slide, they relied on McCulloch versus Maryland, an 1819 case on judicial review, and the state law that conflicts with federal law is without effect. Without effect. And here's this is the words of the Oregon Supreme Court. In sum, whatever the wisdom of Congress's policy choice to categorize marijuana as a Schedule I drug, the Supremacy Clause requires we respect that choice when, as in this case, state law stands as an obstacle to the accomplishment to the full purposes of the federal law. What were those full purposes? The CSA absolutely makes it a crime, and a serious crime, a felony, to, I think it was the word manufacture, transport, sell, possess, all of that. Those are major felonies. Now, the applicant wants you to approve a permit that's going to let him deliver all over the county. And we'll get into that more, because that's not even allowed under your code. But think about that. Does that stand in the way of the full accomplishment of the CSA, which has made this a serious crime? And you'll look back when we get further into it, the letters, you'll see that even the Obama administration, which expressed some leniency, didn't want anything to do with having anything around children, and they were willing to accept minor possessions. I understand all that. That was changed by the Trump administration AG, Sessions, who's now gone. But that was pulled back. It's tougher now. And so keep that in mind when we're accused of speculating about some risk to my client, his property, which is being used by these people, if you grant this permit, to commit felonies next door. But And I have to say, the hearings officer saying I can't determine if it's preempted is, in the face of an Oregon Supreme Court case, just really does amaze me. That's not a hard piece of law. But then let's shift over to what the initially Measure 91 did. It's in a statute now, and I've cited that as Chapter 475B. But the statutes themselves, they cannot be construed to amend or affect a state or federal law pertaining to employment matters. So you can have employment rules that prohibit use of marijuana, and they're going to be valid, even though the state said, "Oh no, you have a marijuana card. You're not going to be prosecuted under Oregon law." That's what the Oregon Supreme Court held. To amend or affect state or local law pertaining to landlord-tenant matters. Excuse me, I hit a button I shouldn't have hit. And that's exactly correct. I mean, as a tenant, you don't have. Whoops, I'm going the wrong way. As a tenant, you can be prohibited from having marijuana on the landlord's property. It's very common. And frankly, as a landlord, I think anybody would be very, very ill-advised to allow it, because if it happens and there's busted, your property, if you facilitated that, could be subject to a federal foreclosure or a forfeiture suit. And that's tough. The feds don't need a conviction. They could go in civilly and they can file the forfeiture actions. And if you want to find out about somebody said, "Oh, you haven't talked about any of them in Oregon," I'd encourage anybody to contact the Institute for Justice. For years, they've tried to pull back on forfeitures. They're tough. They're difficult. And you have the burden to prove innocence. Now you ask yourself this: if something happened out there and this permit's granted, and Mr. Giesler acquiesced in, okay, you can use the easement for this illegal purpose, and he gets busted, what's going to happen to Mr. Giesler? Because under the forfeiture rules, even facilitation puts your property at jeopardy. And facilitation is any act or inaction that would either make it, I think, more likely or easier to accomplish that CSA violation. Well, certainly going in and out of there does that. And so, I mean, it's just, to me, folks, I mean, it's really bad. You've got a law-abiding citizen who has an easement out there, and he has property, and these people want to use it to commit violations of the CSA, serious felonies, and they just demean his risk. Oh, there's no risk, it's all speculation. Well, it isn't. It's a real risk. It's serious.
So, Mr. Willis, I want to ask a question about this, because I think you're getting kind of the heart of the matter that, to me, is one of the most different parts of this particular application and this appeal than what we've had with other grow appeals, et cetera, which is, which to me is this issue of, if you give someone an easement, are you required to allow that person to use that easement however they want it? Or is what you're saying is that because the activity of traveling across that with marijuana could be conceived as an illegal activity under the federal law, that easement holder could say, I'm not going to allow that activity?
That's absolutely correct.
Because let me tell you a little bit of history we've had in some comparisons. We had a case where a grow had to go across BLM land, and the BLM maintained that they wouldn't allow that, and that I don't think that was the end result of I mean, I think something else changed that case. I can't remember, but we've heard that before, that the federal government can't be forced to allow a person that's growing marijuana to be able to go back and forth with marijuana across BLM. Is that, and we've heard the same thing with regard to the city of Redmond has a statute that says no businesses will be allowed that violate federal law, and so you don't have any federal or dispensaries in Redmond. And so does this extend, in your opinion, to an easement?
It does, Your Honor, and even beyond that, I'm trying to find that easement language really quick, but this particular easement, the appellants or the applicants told the hearings officer it's not even relevant. Well, it certainly is, because the code requires them to have access. The only access they have is through the easement. And so it's not relevant?
Well, talk about it. I read the hearings officer's decision to say that they're not going to decide whether the easement's okay or allows it or not. They kind of wanted the hearings officer wanted to not get involved, and I feel like we're being asked to be involved, or some legal authority has to be asked to be involved with whether or not an easement grant or.
That's absolutely true, and I'll find the slide in a minute.
Okay.
Let me just answer that directly. Yes, that's absolutely true. And to me, the very disappointing part of the hearings officer was, he says, oh, I can't do that. I can't construe this. That's for the circuit court, okay?
Mm-hmm.
But then we know there's a conflict. Well, why are we here? I mean, Mr. Gisler's already told him, you're not going to use that. I'm not going to acquiesce in that because I'm not going to risk violating the federal law. There is a conflict. And you look at the words of the document.
And you're talking about the easement itself. Yeah. We've got the easement.
In case of conflict, unlike most easements where you have a dominant estate, which is for the easement user,
mm-hmm. and
you have a servient estate, which is the easement grantor, this one's flipped. In case of a conflict, Gisler dominates. I mean, hello, all of that he pushes aside, so I can't do any of that. But I can say there's no conflict. I can say that it's valid on its face. That is so dead wrong. And let me find that real quick.
Go ahead with your proposal, but I just wanted to say.
Well, when we get to it,
yep.
I'll get back to that. But when you see that, the restatement of servitudes, and
mm-hmm.
lawyer, I'm sure you recognize the validity of the restatement.
Mm-hmm.
It makes it very clear that a servitude.
33 in here.
Let me try it.
Servitude created.
Oops. I don't know what I do here, Matt. I'm in trouble because I have to push next, and I don't know how to make it move.
This is the easement itself.
Okay.
You're just trying to get back to usual.
Yeah.
So I think we're
okay. Yeah, there's the restatement of servitudes, and it's blown up. The servitude created as provided in Chapter 2 is valid unless it is illegal or unconstitutional or violates public policy. It's slide 33 there.
Okay, thanks.
Okay. That was presented to the hearings officer, it's presented to you people, and it is illegal. There's no question about that. They say, yeah, we're going to sell marijuana back there. Well, that's in violation of the CSA. It's illegal. And the other thing I pointed out, it's what would you do if they said, oh, well, we want to shift from meth. Let's sell methadone or heroin or cocaine. Now, forget about your county ordinances for a minute. Just look at that easement. Is that illegal? Well, of course it is. And on top of that, if the hearings officer said, oh, I'll satisfy this with a condition, you have to improve the roadway. You can't compel him, even under the state law, you cannot compel Gisler to acquiesce in that, nor could a court. You can't, and that's because that's our own state law. Measure 91, or Initiative 91, says that. And I'll get a slide on that in a minute. And so there's so many things wrong in that regard, and that is something, and we've told them, hearings officer, tell them again, there is no access to this property. Gisler's not going to give you any. If you think you have it, you go to court. You get a final judgment from a circuit court saying that, Gisler, you must do this. Then I'll ask you this. I don't know of any circuit judges that's going to, in the face of that law, and more importantly, even under the state law that says a person cannot be compelled to violate a federal law, is going to issue that kind of an order. Now, they haven't tried it. I don't know why they didn't. They had plenty of opportunity to find out that it wasn't going to be allowed voluntarily, and it's not going to be. So on that problem, that is a completely sufficient basis to simply deny this application no more else. But I got way out of order here. Excuse me for that, and I'll try to get back. And I wanted to point out, it isn't just on those federal violations. It isn't just the CSA that can be violated. There's the RICO statutes. I pointed all this out to the hearings officer too. That has some other elements in it, but every one of them would be met here, including Mr. Gisler's testimony that his property values would be reduced. He's a developer, he's a skilled developer, he knows those values, and sure it would. look at the exhibit from the operator of the antique shop there if you don't think it's going to hurt the property values. And once that happens, then you've got a RICO violation, and counsel for the applicant says, that's speculative. Ask the people over in Colorado. The 10th Circuit out of Colorado just affirmed a RICO case against marijuana operators. And then I just read in the paper the other day that another RICO claim was brought in Colorado where 50 people were indicted because of a lot of people involved in this, and there's a lot of people involved in this. He's going to have suppliers, he's going to have delivery people, he's got all this stuff going on, and he's right in the middle of it. Just don't take my client in there with you. That's our point. So then, let me get to this slide 7 here. Whoops. And I'm going to ask you to keep in mind the pictorial that the applicant put up about delivering to all of Deschutes County. And keep in mind the description they made of what their application was. Their modified application was for retail delivery and recreational marijuana permit with the primary purpose, and that's important because we're talking about a condition, primary purpose being delivery to the entire county. Now, I challenge anybody to show me anything in your code that will allow that permit to be granted. It is not there. It is not there. So let's go on with that for a minute. And even worse, it's to be operated as an annex to a store in Bend, which he claims will be his primary staple store in Deschutes County. So, and you saw, they just repeated it again. There'll be minor, I can't want to call it de minimis or minor walk-ins maybe. The rest of it's for delivery. There's just nothing in that code to allow it. And I challenge anybody to show me something in the code that will.
So is what you're saying that by them operating as an annex to the Bend store, if I understood their testimony right, that a Bend store can't deliver in the county, so they're going to be taking marijuana from their Bend store to this location and using that as the distribution point? Is that what you're saying?
I don't think you're going to get them to admit that. But if you look carefully at what these words that they have up, and I'll go through this right now. I got slide 14. This is their, this was Mr. Hayes' letter himself when he sent the modified application in. He pulls off the one food cart and farmer stand, and he says this: clarification of the primary purpose of the marijuana retail, and that's consistent with what he said here this morning, pretty much. The primary purpose is delivery service. The site will be used for delivery service to the county. Then he says the expected amount, and that's the part that is meaningless, because whatever his expectation is can certainly change. He's an aggressive entrepreneur. The secondary purpose is walk-in marijuana retail sales. And he knows that. You're not going to have many people walking in out there to buy marijuana in Tumalo. So it's a primary thing. He didn't use the word annex there. But then his lawyer, on his behalf, repeats that with slide 15, proposed use and business model. And then this is the one that I think really gets me, is slide 16. This comes in with the clarification for that modified use. The applicant owns and operates a dispensary within the bid city limits, which will continue to be its primary staple store in Deschutes County. The county. The proposed Tumalo store, which is the subject of the reference applications, will be used as an annex, and focus on that word, annex, to service delivery needs of customers within the county. The store will provide discounts for military and medical card holders and offer free delivery. So this is different than anything you've seen. It's sure different than that one down at Sun River. And that actually, I went back and looked at that, but started out as a medical permission, and Mr. Hayes is correct. There are 0 delivery permits granted by this county so far. And now we'll come to section 17, and I can suggest why. I don't believe your code for at least Tumalo allows delivery. So let's look at this language, and this is the only thing I can hang their hat on. Chapter 1867, 040, and I've highlighted this part. The Tumalo Commercial District is intended, that speaks for the intention of you folks who passed it, is intended to allow a range of limited, and I stress limited, commercial and industrial uses to serve the community and surrounding area. We're going to get to surrounding area in just a second too. Then conditional uses, which it must be. You have to have a conditional use. Following uses and accessory uses are permitted, subject to applicable provisions of, and it runs off those things, and then it says 11D. And look at 11. Following uses may be conducted in a building or buildings, not to exceed 10,000 square feet. Marijuana retailing, subject to provisions of DCC 18116.330. Now, look at what you're talking about here and what occurs in a building or buildings. Yeah, if you walk in and you buy marijuana, you pay for it. It's going to be all cash, and there's a sale. What happens when you call in for a delivery? It isn't like a pizza place where you can call Domino's and give them your credit card and they'll deliver. You can't do that because the rules that they want to rely on under the agency says you have to go out and you have to collect at that point of sale at the delivery. That's where it is. That's not in a building in Tumalo. And so I really do believe that this county's ordinances will not allow these type of delivery things, especially with an annex. And this is where I want you. This is all familiar to all of you, I'm sure, but you're entitled to deference when you construe your own codes. And Lube was bound by it as long as it's not implausible, and if you're not violating an express rule of the code or some other comp plan, you're fine. And what I point out is the permit he's seeking just is not allowed. Literally, it's not. And that's an easy construction for you. I certainly urge you to make it. And that.
Let me just make sure I understand. So you're saying a delivery permit based in Tumalo like this is not allowed? That's correct. That's what you're saying.
Yeah. And
they could be a retail store in Tumalo if everything else worked, but the delivery part's what you're really.
That's correct, and that's because the code says these conditional uses are allowed in a building or buildings. And these sales on the delivery are not going to occur in the building. They're going to occur somewhere out in the county. And according to what they want to do, it'd be at the far reaches of the county, to Jefferson County north and Lake and Klamath to the south and Crook to the east. And I don't know what's west of us now. Is it Lynn or, but huge, vast amounts of that. And now this is the other part about that, why this permit is so bad, this application. It's to serve the community and surrounding area. I'm looking at slide 22, okay? And surrounding area is literally defined in your code. I've cited that section there, and I've highlighted that deal. It's in surveyor talk, but here's a meets and bounds description, or, well, it isn't meets and bounds, but it's a township range description of what it looks like. So we had the tech at Thai Engineering draw that up. I'm not good enough to do it. So there's her email back to Joel. Here's what I did, okay? And she notes that the west line is not straight because it follows land of the Forest Service. There's the pictorial. Take a look at that west line to be to your left. She says that's not straight because that's going to follow the Forest Service boundary. And you look over to the right or the left further, it'll show you that's the Deschutes National Forest. Okay. And then this one I get credit for. I just took this came off the dial section. Looking at this, I said, well, how much are they really trying to do? The yellow is what I put in, trying to roughly match what Ty had given me with that other description. Look at that. Now, this is a code that says it would be allowed in Tumalo and the surrounding area. This is a pictorial of the legal description of surrounding area in your code in yellow. Look at that. They want to go out to Hampton And so, you know, it's so wrong that I'd submit to you it's shocking, and if you interpreted those codes going any other way, it would be implausible. Well, skip that one. They're just pretty loose with dismissing any risk that we have. The other part about that is it has to be conducted in a building. That's the language out of your code. And then to give you some idea, and this is because they say, oh, well, we'll have an OLCC blessing for this delivery because our regulation says we can deliver. Well, you can't, under that regulation, you can't deliver out of bin, and that's where I say, I don't know what they're going to do, but I know this, that they're very bright, they're very smart, they're very aggressive, and I know that nobody's going to be able to enforce anything if an order comes into bin that goes out of Tumalo. It's kind of catch me if you can. So it's a very serious issue. But what I wanted to point out to you is you know, we also have very strict land use laws. And the legislature in 475B 486 1D on the series at slide 29, they list a series of reasonable local restrictions that local governments can place on marijuana. And those include the manner in which a marijuana retailer may sell marijuana items. And your code says to be conducted in a building. So that's why I say you don't have, nobody can point to anybody else in the county where you have given them a permission to do deliveries and sell marijuana to the far reaches of the county. And on this application in the Tumalo community and surrounding areas, by legal definition, it can't happen. It cannot happen. So in this, I would just tell you, I think that you're on solid ground to say the legislature told us, the legislature, not a committee, not a commission, on a regulation. The legislature told us we can put on these legal restrictions. That is going to supersede any efforts of this OLCC by regulation to try to contradict it. And it sure isn't going to be able to contradict your definition of the Tumalo and surrounding area that's legally defined in your ordinance. So they lose. So this goes, now we're back to the access. I'll try to skip through this really quick. But when you're construing easements, one thing you look at is go back and see what was going on when it was granted. Mr. Giesler gave this to a widow lady who was homeless back there already. She and her husband were there. He passed. She granted it. He granted that easement to her. Single family home back there. That was it. And then an illegal use is invalid on its face. That's that restatement of servitudes I showed you, that they're valid unless it's for an illegal purpose, and it is. It would violate the CSA. And then the other thing is, and this is why I try to bring it back to something that we get accused of, oh, you don't like marijuana. That's their speculation. But set that aside for a minute. Here's an example. What would be the difference if they wanted to do a public accommodation back there and said it's not for African Americans, it's for Caucasians only? You think you could compel the use of that easement to do that? Of course not. And that is one of those examples that I gave you in the, well, I can't, my eyes are too bad to read it. But you look at those notes in there and it shows that there was exactly that example. Oh, here we go. It's at slide 34, where in law school terms, they're talking about green acres, that prohibit occupancy of any lot by persons not of the Caucasian race. The servitude is invalid because its enforcement by a state court would deny equal protection. And also, the servitude is also invalid because it is illegal and against public policy. Nothing could be more clear than under the federal law, their activities are illegal. They're major felonies. I'm going to skip through these letters. These are just letters that went in. Miles Conway was helping on the land use side of this at this level. But it was Mr. Geisler who submitted the easement document, not the applicant. They just blithely said, oh, there's an easement, we have access. And this is and Commissioner Henderson, you raised this, but look at paragraph 5. This is the one that changes the law of easements dramatically, because not when there's a conflict, Geisler is not the subservient estate. He's the dominant estate. And there is a conflict, and it's not going to happen. And under the Measure 91 things, he cannot be compelled to let it happen, because you can't compel a person to violate the CSA. And this is the other part.
Wait, before you get to that, I think so. The applicant in their letter that we got outlining their arguments, they refer to, I guess would be a typical easement, is that they call it the dominant tenement goes with the grantee, and they didn't really deal with this wording in the easement that I saw, and they'll have a chance to address it if they did, but I didn't think they did. And so does this override the law of dominant tenement going to the grantee by agreement between the parties?
Yes,
okay.
Of course.
That's yours, and they can respond. And does it, so the question I had is in case of conflict over what? Over use or over allowed use by one party, or over what?
Well, look at in context of this.
Yeah.
The parties shall cooperate during periods of joint use of the easement, so that each party's use shall cause a minimum of interference. Okay? So if you go outside of a minimum of interference, then Geisler, if there's a conflict, he wins. Then he's the dominant estate. If you don't think there's a conflict, and that's the point, or if you don't think they have, what they're doing is trying to minimize both uses of this, his people use it too, his tenants.
But a strict reading of it could be that the grantor, Mr. Geisler, wants to use the easement to park something in it part of the time, and the other owner, maybe the original grantee, wanted to be able to drive through all the time, and so or is it just, you see what I'm saying? There'd be a conflict would be over who gets to use it when, as opposed to can you use it for a purpose I don't like? So is there any space between those, is what I'm asking.
There is, and that's because if you read the letter that's in the file we've submitted to by Mr. Anderson, who runs the antique store, I think you'll know it better by Beyond the Ranch Antiques.
Okay.
Read that.
Okay.
That's not a minimum interference with what's going on there with Geisler's tenants. And so he is now dominant. And I don't think there's any room beyond that. I really don't. But before you even get there, they have to get over the hump that this is illegal on its face. Because what the restatement says very clear, I've not seen anything from them trying to refute that, because it's pretty stable law. It's illegal to do this. And that easement cannot be read or enforced to allow the illegal act. It cannot. So, and then the other thing that really is, I guess, frankly, bizarre to me, the hearings officer went right along with everything that the applicant was saying, but the applicant has the burden of proof on access. He says, well, I can't really construe the easement, but then he kind of did, because he said there's not a conflict under the terms of that easement, and it's valid on its face. Well, that's contrary to the restatement position, but they have the burden of proof. There is a conflict. It's set aside everything else, set aside the language or anything else. There's a conflict over this between these two people. He has the burden of proof, the applicant does, on access. Without the easement, it's clear he has no access. So how does he prove that he has access in the face of this dispute? He has to go to court, and he has to get a final judgment from a circuit court saying he does. And we pointed that out before, and that's where it should be. And I just submit to this to you. It's just terrible policy in construing these things to ever send two people out there at the driveway for self-help. He's to rebuild a barricade. I don't know what Mr. Hayes will do, but if he wants to go to court, he knows the way to court. He knew the way to court before all this started. And let me point out one other thing about this, about context and considering these things and what was really bothersome. You have a different code. It's on slide 41, DCC 18116 330A3. That doesn't apply to retail marijuana, but it does apply to production. But there, because you're mostly going to be further out in the rural area, where you have an easement that more than one user, then you do require a clear written statement, and actually it'd be very binding, that you have permission to do it. That's the context we're looking at some of these things, and I don't know why that doesn't appear over in the TUC code. I suspect it's because when you look around at these more urbanized areas, like the little community of Tualatin, most of them do have direct access. This site used to, but the applicant's predecessor owner vacated those streets. They got free dirt in the vacation, but they vacated them, so it's not there anymore. And I really tend to believe that probably that's why it's set up that way, because most of the time in the more urban areas you're going to find direct access. And here you don't have it, you have that easement. But that sure points the way to what to do about this. If somebody wants to have their burden of proof, go get the easement owner to say, okay, I agree, you can do it. And they didn't, and they need to lose until they do. Then let me talk a little bit about the traffic impact. These are separate things. If you read the letters that are in the file from Peter Russell, he was here this morning, you can see that very hard to figure out.
He's still here.
Okay, all right.
Right there in the front row.
Forgive me, I can't see that far anyhow, but there's clearly problems in interpreting the data they gave them. And the hearings officer been a lot with them, trying to help them on that. But he does point out that there is 27 more peak PM hours than is there. Somewhere else in those letters, I don't have it highlighted for you, it's in this record. And before I forget, I want to make sure that the entire record of all the materials that either me or Mr. Conway or the Giesler submitted directly is in this record before you people. And
I think it is. We've got a big book, a binder up here that's full of, it's supposed to all be in there. So.
And, but then another deal, there's 220 raw additional trips per day coming across that, 220 per day. That's enough itself to say, no, I'm not going to allow that across mine. I'm not going to do that. That's too many. And then look at what Rob Anderson tells you about his use of that going back and forth.
So just take a moment, Mr. Chair. You mentioned 20, 30 minutes. It's been 35 minutes, and there just seems to be a big, thick pile of papers here. So I'm just acknowledging kind of procedure and policy of how we want to proceed.
It was 12:12, so it's been about 40. Yeah.
I'm sorry. Can I
40 minutes.
Keep going? Do
so we know you've got some more and some of it's I've interrupted. I know. So we gave a little additional time to the applicant. I don't know which parts are more important than others.
Let me flip through them real quick, and I'll
okay.
I can do it. Okay.
Finish up by maybe 1
Well,
o'clock.
there were sidewalks also in your code that's required, and they said no, you don't have to have them. They won't go in there if they're needed. This idea that nobody can compel him to acquiesce in this illegal use next door across his easement, that can't happen. And then this is the other thing about the credibility issues, and this is why I told Mr. Hayes I was disappointed. He filed these certifications. They were back earlier. He filed 2 of them. The original certifications, I'm not going to go back. They're in front of you in those early slides, where he certified, to the best of his knowledge, this met all local and federal laws and state laws. He has to know better than that. I mean, I don't think there's anybody in his business that doesn't know that the CSA makes this illegal, and yet he signed that. And why is that important? Well, first of all, a lot of people maybe didn't realize what was going on out there. Maybe there'd been even more opposition. But Oh, and then he now says he's got a surveyor. I do want to see that survey, and I want to have an opportunity to object to it and rebut it, but if it's there. The reason I say it matters on these forms, that form is a county form. It's promulgated by the county. It's 2208. And then under 2208035, the application could have been declared void. It could have been declared void. Just stop right there until you fix it. It wasn't. It should have been. And the hearings officer really demeaned the person from Thai Engineering, who honestly said he came out with it being just barely under 1,000 feet, very close. But he said, I cannot give a warranty of the precise, so he said plus or minus. And he said, why? Because the county shows that thing is done. I'm just going to jump through these others. But I do want to, going back to the conditional use and the site review, council really blurs over the requirement that it be harmonious and compatible with surrounding uses. Look at the code provisions on that. And it isn't just the elevations, which themselves are problematical for that community, but it's the uses. And when you look at that antique store, you look at that Spanish school, it's not, it can't be. So if you look at 73, that's the Controlled Substances Act provisions. And then look again at page 74. What I wanted to do is just have you look at that. You can look at it at your leisure about what it means to facilitate a violation of the CSA and what risk it puts you to for forfeitures. It clearly does. And then finally, the only way that he can satisfy the access for this is through that condition that was imposed. That's conditioned on him, not Mr. Giesler. Mr. Giesler's not going to obey it, and you can't make him obey it. And consider this. Under Nolan and Dolan, I think most of you recognize those names. I was privileged to represent the Dolan family when that case came back from the Supreme Court. But under those cases, there has to be nexus, and it focuses on the nexus between the person who is being conditioned to do something. Well, Giesler doesn't need any permissions to do anything. There is no connection between Giesler and this use that the neighbor wants to make. The same with Dolan. Dolan, you are limited to conditioning somebody for something that's roughly proportional in nature and degree to the use that they're making. Giesler's making no use of it. And so sadly, I mean, if you did it, I hope you won't, but if you did it, you're going to invite an inverse condemnation case against those cases against the county, and that would be doubly sad. And I'm sorry I have to keep going, but I want you to look at slide 77. Look at the comments of the U.S. Attorney about slowing down, look at these problems. And then okay. I would just ask you to go ahead. I got way out of order trying to answer questions. I apologize, and I apologize for taking more time than I probably should have. But I would like the opportunity to at least see what has been filed. I've not, and especially I'm interested in that survey. I want to see if it is a survey, and I want to have an opportunity to look at it carefully, and then to reply further.
Great. Let me ask one just legal question, because I'm going to ask the applicant too. So it seems to me, so the land use hearings officer basically, to me, didn't really deal completely with the easement issue. Basically the decision was, well, it's not kind of beyond my scope or whatever. And I have the same question in a land use matter. Should the requirements on the easement be before us as a quasi-judicial land use decision maker, or should it be interpreted at a court level as to whether someone can be, for instance, if a blockade was built, then the applicant would file to open up the blockade or whatever. Is this the right body to be hearing this easement interpretation?
Direct answer to you is this. I think it is the circuit court jurisdiction to make that final determination. But when you have the burden of proof on the applicant to have access, and all they can point to is the easement and the person who owns the underlying fee, and then under the terms the dominant estate says no, the applicant cannot meet their burden of proof until they go get that circuit court judgment. That was my point.
It's in our scope of analysis to look at that and say, we interpret the easement this way. Now, the circuit court could reverse it or whatever, but we have that. You think we have that authority to say?
That too, to some degree. And
just asking your opinion. I'm going to ask the other attorney, because it seemed like the hearings officer didn't want to do that, so they.
But I do agree this. I mean, the circuit court will have the final definitive say on those issues. But my point again is pretty simple. It ain't going to happen. You know, we've told him, and he's going to do it. There'll be a barricade that goes up if this is permitted, so it ain't going to happen. That condition will not be satisfied, and if it ever was satisfied, you're going to buy into an inverse condemnation case under Nolan and Dolan for doing that to him. Send him to circuit court.
That we would be liable for inverse condemnation by allowing
by imposing that on Geisler
on the Geisler property. Yeah. Okay.
And the other thing whatever, I think I've covered it. I hope. If anybody else has any question, I'd be happy to answer. Yeah. But it's clear to me there's no question there's a conflict. I mean, forget the language of the lease. There's a conflict. Not going to use that easement. So he can't satisfy his burden of proof unless he goes gets that court order. So, thank you.
Okay. Thank you.
Thank you.
Good.
Afternoon. I'm Joel Geisler, and I don't know if you have these papers. I don't have the.
I think we just got them here.
Okay.
So is this continuation of the appellant's testimony?
Yes.
Okay.
I'll be quick because I'll just go through these. It's all written.
Okay. Thank you.
If you just follow through.
I think we'd intended to have the attorney and you be within the same timeline, because that's kind of what we had with the other, but they'll get another chance, and hopefully we'll get to hear.
Follow through with me. I'll just read it, and there's not that much, and I'll skip the access because that's been covered.
Okay.
See so the first page has present use, and on 4/15/16 they got the approval for the food court, and then applicant purchased it in 3/13/18, and I provided pictures showing that he has not kept up the property according to the existing site plan. And he's also parked a trailer in one of the spaces reserved for the food court. And I thought it was ironic when they said that they're not going to have a branded truck or trailer going throughout town. But if you look at I think it's the fourth or fifth picture, there's a big trailer there with Miracle Green all over it. And then I have pictures where they're parking in the landscaping. But anyway, the proposed use is for delivery, not retail, which is not, delivery is not a use allowed in that zone. And then additionally, they don't have an accepted traffic letter, and I provided the memo from Pete Russell a couple times, and I highlighted where he says the traffic letter submitted by the applicant is not acceptable by the county. And then on the setback, if you look at the last page of, there's his site plan, and I showed where he could easily move the building to meet the 15-foot setback. There's no impediment. There's no existing development or anything else. So clearly he doesn't meet the exceptions to the setback to increase the minimum setback. And then on distance, so if you want to go to that next deal. There's the distance. The survey's new to me. I resubmitted the map from Thai Engineering. And then also, the Spanish school is not just a school, but it's also a youth activity center. And I submitted her letter, which was already in the record, that she teaches math. And then I also received an email from her that she does use minors. And I wanted to submit something new. I talked to the Tumalo Church, which with the map shows it's 960 feet. And there's several emails from the Tumalo Church. Our church has regular activities that include children of various ages and may include a preschool in the next few months. And then there's another email. In answer to your inquiries, our church has regular activities that include children. In addition to the regular activities, our church does from time to time host on our property youth groups from the valley who use our property as a center for their activities while in Central Oregon. I hope this will help to answer your inquiry. And there's one more. You and the county commissioner should also know that we do have some playground equipment on church property and allow neighborhood children to use it. So clearly the church is being used as a youth activity center, and it's 960 feet from the applicant's property. Access, I'll just skip.
I want to ask you a couple questions.
Sure.
So you've got the written statement from I can't read the name on the Spanish Learning Center. You've heard the applicant's testimony that there is no school, nothing's taking place. So can you tell us any more about that, or is there somebody here to testify about that? Or
She is a tenant of mine. She's leasing there. I think she's had some health issues, so right now it's not being used.
Was she doing this activity somewhere else previously, as we were told? And,
yes.
And so this is the new location where she's.
The new location.
And how long has she been there?
December.
This is December, okay.
December 15th.
So this letter is the start, so to speak, or? Okay. Thank you.
The church is definitely within the 1,000 feet.
Okay.
And I'll just skip access. Joe's gone over that. And then harmonious. Harmonious definition will positively fit with neighboring properties. I have been to many public hearings, and all of the people unfortunate enough to have a marijuana operation as a neighbor has never said it was harmonious. Further proof is decided that Deschutes County is expanding restrictions. I understood this effort is being appealed by a group. Also on this, I submitted a letter during that August 28th hearing, or August 28th, 18. Ben Park Rec asked to be included in the separation distances. And then I contend the proposed marijuana business crossing my property caused me to break federal law and exposed me to forfeiture. I provided 3 articles, one from OPB dated 1/13/19 that explains the overproduction problem in Oregon. In the article on page 2, it states that U.S. Attorney for Oregon is committed to reining in the state's cannabis black market. It also states that only 3% of the retailers have had compliance inspections and only 1/3 of the growers. So it's clear nobody's being oversight. They're just doing whatever they want. And so the risk is high that they could grow afoul of the law. These numbers that tell us there's no oversight in the marijuana industry. Oregon Secretary of State Dennis Richardson commented, as the market is still developing, agency tracking of Oregon's marijuana supply and inspections is lacking. This increases the risk that marijuana businesses in Oregon will find themselves subject to federal scrutiny. This increased risk and lack of inspections will translate in more federal oversight and increase my exposure to federal action against me. This is not right. The county should not create a situation that will subject me to risk. The second article is from News 21, dated February 8, 2019. In this article, applicant's attorney, Stephanie Marshall, states people who are in the marijuana industry have a federal cloud and fear what might come along with federal enforcement at the federal level. At the November 29th hearing, and also today, Marshall downplayed federal forfeiture as speculation and fear tactics. Clearly, she knows that the feds could involve me in applicant's operation and cause me harm. I do not know applicant's operation, nor do I have any control. If the feds decided to prosecute me as an attorney, as his attorney said they could, I may be involved. This is not speculation, but the applicant's attorney's own admission, a reality. The county should not put me in a position that exposes me to federal prosecution or forfeiture. The third article is from the Bulletin dated February 23rd. In this article it states that we have the most number of retails per capita and there are a lot of people struggling. With no oversight and no profits, incentives are high to break the rules. And Measure 29 states that I cannot be required to break federal law. I also include a letter from Rob Anderson, who owns an antique store. He is opposed to the proposed use. Applicant does not meet harmonious requirement. In the conclusion, failed to maintain and operate property per existing site plan, false statement on land use application, failed to provide acceptable traffic report, does not meet required setback criteria, no access, separate distance from state park and youth center not met, use not harmonious in multiple areas. County could not approve an application that subjects innocent neighbor to risks outside their control. And you can look at the articles. I've highlighted the pertinent. So that's about as quick as I could do.
Good. Thank you for providing that. Any questions? There.
No, I just want to review all this additional documentation.
Mr. DeBone?
No questions. Thank you very much.
Thank you.
Yeah, thank you. So, I think that went almost an hour, so the applicant will have a little additional time, but maybe we could do that in the rebuttal period, hopefully to cover that. Yep. I'm not sure. Yeah, do you know the? Yeah, okay.
He knows it.
We usually talk about that at the end, so.
Currently, the final day for the county to take final action is May 16th.
May 16th, okay. So this is a period of time when we go through the public testimony. We'll limit that to 3 minutes. So the first, let's see. These are in the order I believe that they came in. So the first witness is Dr. Gail Davis, and followed by Tim McGinnis.
Can you hear me? It's hard to hear back there. So can you wait to start that 3 minutes? I'm not quite ready yet. Thank you. Can you just put it back to 3? It doesn't go in reverse. Thank you.
My name is Gail Davis, and I live at 655 Tweed Road in Tumalo. I have a doctorate degree in education and was a teacher and principal at both the middle and high school levels. I was also a professor of education at the university level and a board member for 10 years in one of the largest youth centers in Portland, SEI, Self-Enhancement, Inc., and I'm also on the High Desert Board of Directors. So I have an extensive background in youth centers and also obviously in schools. During my 35 years in education, I've worked with over 40,000 students, during which time I've designed and implemented many drug and alcohol programs for K through 12 students. This is what I know from all of this education and experience. Why do kids use drugs? Because of low self-esteem, escape depression, loneliness, peer pressure. Kids do not use drugs because there's a liquor store or dispensary near their school, or a youth activity center, or place where youth gather for all levels of activities. Where do kids get drugs? From older siblings, cabinets at home, peers, black market dealers. Kids do not get drugs from OLCC-controlled liquor stores and dispensaries. Dispensaries are, in fact, strictly controlled with comprehensive camera coverage, both inside and out. Additionally, the public is unable to even view what's inside cannabis stores, unlike a grocery store, such as your own Tumalo grocery store that has beer and wine on display for all ages to see the minute that they enter the store. Where do kids learn about drugs and alcohol? From social media, peers, family members enjoying beer and wine at home, in restaurants, get-togethers, such as your own Bite in Tumalo, where kids are present. Kids are not allowed to go inside dispensaries, and there are no areas for cannabis consumption anywhere near a dispensary. To kids, it is simply a building. Dispensaries do not contribute to drug exposure and use with youth. In fact, having a dispensary in the community actually keeps drugs away from kids. There are strict state and county controls in place from seed to selling point. The problem lies in the over 636 active medical marijuana growers in Deschutes County, which are unregulated and therefore free to sell their marijuana to anyone on the black market. By having a dispensary, it reduces the need for these medical grows and the black market sales. By having strategically placed dispensaries throughout the area, in this case Tumalo, actually gives control and leverage to the county to begin to shut down these unnecessary medical marijuana growers and capture the thousands of missed dollars in taxes that you are not getting by allowing these growers to continue. The best way to keep our kids away from alcohol and drug use is to have tightly controlled dispensaries in their communities to combat black marketing, ongoing drug prevention programs as part of an everyday curriculum in our schools, strong counseling centers, and elective programs that enhance children's self-esteem. The Tumalo dispensary has gone through an extensive and thorough process resulting in an unbiased decision. The only thing that makes sense here today is to support the already approved dispensary in Tumalo. Thank you. Any questions? You've got an expert up here. I'd be more than happy to answer your questions on youth centers. And I can add, in terms of a youth center, I have actually spoken to the Spanish teacher. She is unauthorized.
Your testimony, we told you had 3 minutes. If you wanted to talk about youth testimony, you could have talked.
Do you have any questions?
So I don't have any questions at this time.
Patty? No questions.
Yeah, so the fact you're an expert in education is great, and we have our ordinances that say these are the rules, and there was a time last year we were looking at all the rules, so that'd been a good time to talk about setbacks, but we kind of have our rules. But we've got a lot of people here that want to testify today, so nice to engage you maybe later about some of that information. Thank you. Tim McGinnis, and then followed by Sam Davis. You'll come up to the table here.
Commissioners, thank you for allowing me to speak today. All of the commissioners here know who I am because I'm one of the anti-marijuana grow people. I do not believe that there should be, as you know, I do not believe marijuana should be grown on farmland. I believe it should be in light industrial. However, given that, the state has seen fit to allow marijuana to be grown and to be distributed. It should be distributed through dispensaries under the law and not through hearsay of people giving testimony. Now, the school does not exist. The Spanish school does not exist. I have been down there. I have looked. There is no reason that it should be put in the record as being a school. The other thing is, and I take exception with my friend, Counselor Willis, that federal law rules. Yes, it does rule, but only if the United States government, through the Department of Justice, defines that they will enforce the law. And it is very clear that the federal government is unwilling at this point in time to enforce the marijuana laws. However, if they choose to do it, then all of the marijuana issues in Oregon will go away because it will be federal law. Thank you.
Thank you.
Thank you.
Questions?
Oh, thank you. Sam Davis, and followed by Jackie Schertzinger. I think I have one here. There's one here. I've got Sharon's.
If I do, I'll get a second one.
Maybe I'll get one. Yeah, she'll get hers. Yeah. For anybody that wants to make additional testimony beyond the 3 minutes, I'm sorry the limitation, but we've got other meetings this afternoon. It's supposed to start in 10 minutes. It won't. You can't. We will probably allow more written testimony as well, which we will review. So thank you.
I'll try to get through this very rapidly. My name is Sam Davis. I'm a resident of Tumalo, and I'd like to make comments about the consistency of approving this permit with both the comprehensive plan of the county and the Tumalo community plan. One comment is that this business will be within 1,000 feet of an existing public trail that's on the Bend Metro property. Secondly, the impact of the project on the intersection that's, again, part of the community plan for Tumalo is significant. And third, the impact of the traffic, which increases the danger of one of the more dangerous intersections in the county, which is the Cook intersection with Highway 20. The Tumalo plan references trails, as does the comprehensive plan of Deschutes County. And there is a trail that sits 697 feet from the property in question here. I walked out yesterday and actually saw footprints on the trail, and you could see where people had been cross-country skiing on it. Next we have a concern. So here's a picture of the trail that's in the Bend Metro data. You can see where it ends. It ends at the end of Cedar Road or Cedar Lane. Here is the same map. You can see it in red from the county's comprehensive plan. Here's from the Tumalo plan showing the same trail in black. Here is a section from the Deschutes dial showing that the property in question is owned by Oregon Parks and Recreation District. And here's from Google Earth the information showing that it's 696 feet away from the proposed location. So my conclusion from this is if you approve this project, you're approving something that's 696 feet from a trail, and that's in violation of the 1,000-foot setback we have, separation requirement. And that property is, in fact, according to Dial, owned by the Oregon Park System. So it's property owned by the parks. Secondly, we talked about briefly the intersection of Cook and Highway 20. In both the county plan and the Tumalo plan, they reference this. Two of the commissioners were at a presentation by ODOT saying that this was going to happen. And if we approve this, here's the photo of the overpass and underpass showing that this property would have to be taken by eminent domain. This was presented by the county on, I think, February 8th.
Sam, I'm going to have to cut you off.
All right.
I believe we're at past our 3 minutes. And
All right.
It looks like
conclusion is this is inconsistent, and 373 additional trips through one of the more dangerous intersections to me is in violation of our codes.
Thank you.
Thank you.
So the next is Jackie Schertzinger, and then Doug Macbeth. Doug Macbeth after that. Okay, yeah. Jackie, go ahead.
Good morning. I'm not a lawyer. Maybe that's a good thing. My name is Jackie Schertzinger, and I've lived in the Tumalo area for about 20 years. My daughter and son-in-law and grandkids, they live in the Tumalo area. My grandkids have gone to school at the Tumalo school. I presently have a grandson attending Tumalo school. And so I have over 400 reasons not to have a pot shop in Tumalo, because there are over 400 students K through 7th grade at Tumalo School. And I know that's not a legal reason. It's more of, to me, a moral reason. And I also this morning on the way here stopped at the gas station in Tumalo and clocked the mileage, and it was right at 4 miles up the road south to the first pot shop right there by Jimmy John's. There's a cannabis store there. So, you know, I realize people do what they want to do, but they can go 4 miles down the road as far as I'm concerned. And then my last thing, I still have a minute left, is it's a different tack, and it's a book written by a man. His name is Alex Berenson, and he wrote a book called Tell Your Children the Truth About Marijuana, Mental Illness, and Violence. And it's published by Imprimis, and it's by Hillsdale College, if you're familiar with that college at all. And I think I did not think I had to have copies made, but the secretary has a copy. So I ask you, it will only take 10 minutes of your time, but it's I think it has some very factual information in here about the use of smoking cannabis and the increase in violence and mental illness. And so that's all I have to say. Thank you for your time. And, you know, you have a lot of information to go over. I realize that. But I just want to say that as a person in the community, that I don't think it would be a benefit to the families that live in this area. Thank you.
Thank you, Jackie.
Thank you.
Questions? Okay. So next is Doug Macbeth, and followed by Garrett Wales.
Good afternoon. May it please the board. My name is Doug Macbeth. I live on Tweed Road in the county. I'm a board member of Miracle Greens, which is one of the most successful dispensaries in Bend. And I have to say that that's no small accomplishment. between the heavy regulation and the federal tax situation, running a successful compliant dispensary is a big job. And we have done a great job so far, and we'll continue to do a great job in Tumalo. I passed my first bar exam in 1983. I've passed a couple more since then, none in Oregon. But I spent 20 years doing land development work. And this building on this location is going to be an improvement to the Tumalo area. I go through there every day. I'm in Tumalo all the time. I also, with regard to the ODOT, that slide you just saw is one of 3 possible scenarios for the improvement of 20 and Cook. The other 2 actually involve traffic circles, like the one up in Sisters, which would involve a slightly lesser taking. I've spoken a couple times to David Brown, who is actually in charge of the eminent domain process for that project. And we're keeping a very close eye on what happens there. With regard to the easement, an easement is an estate in property, just like a deed. There's consideration paid for it, and what it says on its face is what it means. The application of the law to easements or deeds is a state matter defined by state law, as, for instance, the eminent domain code is in the Oregon Code. And so anything varying from the face of the easement would have to be a matter for a complaint. And any action which impeded that easement for our benefit would be subject to civil remedies that we would certainly pursue. But I don't think it's a matter for the consideration either of the board or anybody but a circuit judge. And I would also say, finally, I spent 2 years writing opinions for the presiding judge in the county where I grew up. I read the entire opinion of the hearing officer, which I thought was remarkably well done, and which completely and conclusively shut down every single argument you've heard today. So I commend it to your attention, as well as his reasoning. Thanks.
Thank you. Garrett Wales, and followed by Nenzi Gould. Okay. Nenzi Gould. And I have Dr. Gail Davis again. So, yeah, I know she was. I'm just trying to figure out why there's 2 applications. So, Tim McGinnis has 2 also. That's weird. Thank you. Oh. Okay. Thank you.
My name's Nenzi Gould. I live in Deschutes County. I've been around for about 28 years. I don't see a testimony sign-in sheet. I'm hoping that that gets delivered into the record so that that can be part of the record.
Other than these, or?
Well, typically there's another one that references the land use. So however it is that you do it, if it's your testimony sign-in or however, but typically there's another form with the file number, et cetera. So I'm here recommending that this board deny approval of 247-19-000754-A. There are pre-existing conditions to the current owner, H2D2's land acquisition of the site. They bought it about a year ago on March 13th, 2018. The front yard setback is not met. I see no reason to rationalize an exception in this case, especially since this is the first application before you that involves delivery. The site building is less than 700 feet from the Tumalo's Cook and 7th State Scenic Bikeway. You have a picture of that, which I took March 2014. The site building is less than 700 feet from Deschutes River Trail at Riverview Avenue. This soft surface trail is actively used by the youth in our community, and I have a picture summer May of 2016. I don't have 3 copies, but it will be in the record. Actually, I do want to show that at the end of my testimony because that's the youth of our future, the child shown on his pedal-less strider, his bicycle, with his mother and their dog. The location of where they are is on the yellow map I handed you, on Riverview, south of Cedar, closer than 700 feet to the proposed dispensary. Giesler right over his easement cannot be overruled. There have never been 5 food carts at this site. At max, the food court had 3 carts. H2D2 today has 1 food cart and a trailer advertising Miracle Greens in very visible lettering. There's no approval to allow the dispensary to advertise their business while 1 food cart is operative. They're doing that today. And the 1 food cart, Yoli's Burger, which used to be on Bruce Avenue, is the one that's now at this site. So basically there are no net, under today's conditions, no food carts that should be calculated into this transportation count because the one from Bruce got moved to this site. Since the community plan has supported healthy recreational community, we have developed since 2010. The youth activities, the Tumalo River Trail, the bike youth games, the floating from Tumalo State Park all the way through Tumalo to Twin Bridges, and the State Scenic Bikeway are examples of the healthy community we want. And I'll wrap up. I have more in my testimony, but on the Inhale Trail advertisement, Inhale Trail is a business registered in the City of Sisters, which has opted out of marijuana. This shows you about compliance and capability of compliance. We do not have that today, but I'll read the bottom. Cannabis has intoxicating effects and may be habit-forming. It can impair concentration, coordination, and judgment. Do not operate a vehicle or machinery under the influence of this drug. For use only by adults 21 and older, keep out of reach of children.
We need to wrap up. I can't let you go over. I've had to cut off.
I'm going to wrap up.
We need to wrap up.
The issue is setbacks. This does not meet setbacks. Thank you.
Thank you. Sorry.
And I'm going to hand some testimony when I get it all.
Yeah, there'll be time to add some additional. Thank you. The final one that I think I have here is Beth Griggs. And, Beth Griggs. And is there anybody else that thinks they've turned in a form and hasn't been allowed to speak? Or if you have, we can still get another form in. That's all I think I have in my pile here. So thank you.
Hello, everyone. My name is Beth Griggs, and I am the current manager of Miracle Greens. And I'm just here to touch base on a couple of things that I heard through the opposing side. They say that we are aggressive, but I would like to say that we are inspired. We're trying to spearhead something that will help the community that hasn't been done before. So, of course, we're going to be a little excited about that. We track seed to sale for every item. I helped set the process that we have in place in regards to standardized operating procedures that allows us to ensure that what we say we have within our store is actually present. And if it does leave the store or is coming to the store, we have step-by-step directions. We have to go according to a map. If we were pulled over not on that route or within compliance for something like delivery, we could have our license as a bud tender pulled from us, let alone who knows what could happen to our business. So in regards to foul play, it would be kind of silly for us to be operating in any way, shape, or form illegally if we are putting ourselves in the limelight to any extent. With delivery, we have to go through a rigorous amount of things to even have that come to fruition. So there's a system called Metric that tracks every single sale, waste, transaction that happens with our product. And that can be pulled at any moment for anyone's review. We have to have it metriced to the customer. We have to check the ID on site. We have to tender in cash. We carry a box that has to be locked, like with master locks, and then locked to my car in addition to that.
Do you do delivery now then from your current store?
We have in the past, but currently right now, just due to the season and due to staffing, we have paused. But we have absolutely, and we have a process for it to stay within compliance. In regards to the Tumalo store being called an annex is defined as a building joined to or associated with a main building, providing additional space or accommodations. So really, like Diamond Tree, Substance, any of these other dispensaries with more than one location, or really any business with more than one location would have an annex of some sort. And I guess that's my time.
Okay.
And you were talking about in Bend delivering?
Yes.
But you're on a pause now.
Absolutely. Because we have to formulate our own system to stay compliant. We're trying to tread a really awesome path, and we're very excited.
Thank you. I think that completes all of the comments, citizen input, so that would be then the rebuttal by the applicant. And we're trying to get this done in reasonable time, so whatever you can, yeah.
It would only take me another 45 minutes.
There you go.
I was thinking maybe 15 at the most, but whatever you can get it done in.
I'm not going to use even the whole 15.
Okay, that'd be great.
And thank you again, everybody, for your attention. I know it's been a long morning to afternoon, and it's great to be able to put everything before you. Okay, so with respect to the standards that are applicable, I wanted to touch on some of these comments on youth activity center, churches, other things that have given me a little bit of pause. I wanted to direct your, and this is in my letter that I sent to you guys this morning, actually. The Oregon Statute 475B 454 states the provisions of ORS 475B 010 to 545, so that's the marijuana regulatory statutory scheme, are designed to operate uniformly throughout the state and are paramount and superior to and fully replace and supersede any municipal charter amendment or local ordinance inconsistent with the provisions of that same statutory scheme. Amendments and ordinances that are inconsistent with the provisions of that statutory scheme are repealed. So, as you all are aware, the regulations that were adopted last fall, there was an appeal. That's been withdrawn because I know the commissioners are going to be revisiting the county's marijuana regulations.
Just to clarify that, that's what's been said by Clifton Law Group. They were withdrawn at the advice of counsel to augment the record because issues were raised on appeal that hadn't been raised below. And so we don't have any intention at this point, just publicly, this doesn't seem to be out there, to actually revisit the regulations. That hasn't been the goal. So just so you know that, I've seen the newspaper articles and things, and it's inaccurate.
Oh, well, I'm using the term that's used in the LUBA regulations, which says withdrawal of a decision, a land use decision, and that's the provision under which the county was operating. So
we withdrew the decision, but it's been then put out that we're going to redo the regulations. That wasn't the intent of the withdrawal.
Well, again,
so
we might be off course here, but your counsel.
Yeah, we are, but it's out there publicly, and we've been criticized about it by growers and by lawyers for the growers that we're doing something we're not. So just so you know, going forward.
Again, I'm sorry if that's been out there in a way that might not be consistent, but I was told by your counsel that it was going to be revisited within, instead of 90 days, 180 days. So again, but that's kind of off topic. What is on topic is youth activity center, and it's not defined in the code. Commissioner Henderson, you mentioned that you've had a few decisions that have attempted to put some meat on the bones of what that might mean, but there's really no direction to any landowner or somebody that's looking to do their due diligence, as Mr. Hayes did here, what is actually restricted. I mean, it seems that based on the decisions that, it might be a youth activity center in one case, it might not in another, but my comment here is that that nothing has been established. There's no Spanish school, there's no children on the property, there's nothing other than the bald statements of Mr. Giesler and his attorney that it may or may not be there in the future. It's just not operational. So on that basis, we allege that it should not be denied for that reason. Going through my notes real quickly here, and I'm cognizant of the time, I would like the opportunity to address the legal arguments on delivery. It's clearly contemplated by the OLCC regulations. It's not separately broken out under the county code, but it is a component of a retail operation, just as if you've got a pizza joint that's going to be delivering pizzas. They don't have to separately apply for the ability to deliver those pizzas. It's not an annex to the Ben store. This is a separate application, separate operation. It's not, and I'd like the opportunity to make the legal arguments to address the appellant's attorney's argument that that it would not be conducted in a building based on where, based on allegations about, the delivery issue. No one can enforce is one of the notes that I took here. That it's difficult to enforce. I mean, the county has adopted its code. The county has its standards in its code. Enforcement of provisions of its code is not a concern when you're looking at an application and the standards that apply. You can go through and as Commissioner Henderson has said a few times, what are the facts? What is going on here? And we submit that the facts comply with each and every standard, and enforcement may come up in the future, but we can't presume that it will. We can't assume and punish somebody for an act that may or may not ever occur by denying an application because maybe there's going to be enforcement issues in the future. I did write a note about Mr. Giesler's attorney's essential threat of litigation if you were to grant this application. This is going to be an inverse condemnation and you're going to be seeing a lawsuit. That's not a basis on which the county can grant or deny an application. And, we would also submit that we're prepared to vigorously defend our property rights and our permit, the fact that we would meet all requirements of the permit such that it should be granted. All right, so again, just going through my notes real quick here. I wanted to touch on Commissioner Henderson's questions on the easement. Again, this is not the forum in which we can debate whether the easement, whether Mr. Hayes can use the easement, which says ingress and egress. The terms of that easement, you know, it's the four corners of what it says. You know, you're not sitting as a judge. You're not litigate. You know, we're not litigating whether or not that easement exceeds the scope, whether use of that easement exceeds the scope of the easement, what the party's intent was at the time it was granted. You know, any of that stuff is really beyond the purview of this body and would have to be decided by a judge.
Well, can I ask you the same question that I asked the attorney for the appellant? So should we just pause all this while you all go to court, circuit court, and get a declaratory judgment on this? Because to me, they are tied together somewhat. And so if we don't rule on it, it's still out there. If we do rule out, it's still out there. I mean, you know, so that's that. Yeah. So what are we supposed to do? It's obvious to me. It's an obvious issue in this approval because there does have to be some access to this premises. So.
And there is access to this premises. We have a statement that the property owner over which the easement runs is going to take some action. That hasn't happened. You know, we can only do what was before us, just as you've said. What are the facts? The facts are there's an easement. The facts are it's recorded. The facts are there's consideration paid for that easement. And Mr. Hayes has property rights just as the appellant has property rights. As a decision-making body, you can't somehow directly or indirectly deprive him of his property rights.
Yeah, but you want us to acknowledge the easement but not read it. And so I asked the other counsel, I mean, you didn't, in your legal argument, you didn't address the issue of the clause that says in the at least I don't remember seeing it.
It's in the written materials.
If the wording is there, you continue to call the grantee the dominant tenement, and there's this dominant use waiver or whatever you want to call it. So.
And if I may respond on that, the argument by the appellant's attorney is that somehow flips this dominant, servient, tenement idea on its head. It doesn't say that in the plain terms of the easement. You know, that's his interpretation. That's what he wants you to adopt, or the court, or whomever this comes before. Again, this just goes to show that this is way beyond, you know, the matters that are before you.
What does it do if it doesn't flip it? I mean, if it doesn't flip it, what's it do?
Your question to the appellant's attorney earlier was right on. What does conflict mean? You know, does it mean if there's a car parked there that there's a conflict, or does it have something to do with the use? You know, that digs down into what the intent of the parties might have been, and that is not for this body to decide. That's for a court to decide. And the hearings officer was spot on. He said, the only thing I can do, if you look at the code, and you know what, I'm going to pull up right here, page 3, starting on page 3 of the hearings officer's decision. This is okay. So, page 6. This is the second to last paragraph in the hearings officer's decision. The hearings officer acknowledges that DCC 18-128-015A2 does not address the level of analysis required or acceptable to satisfy the access factor. Right there. The hearings officer finds it is clear, however, that a decision maker assessing the adequacy of transportation access to the site must make some level of analysis that it is the scope, I can't, the wording here is a little confusing. That is the scope or extent of the analysis will be determinative in this case. So, going on to the next paragraph. The hearings officer is to make a facial determination that legal access does exist. We have access. We have an easement. It says we have access. We've been using that access for the other commercial use that exists on the property. Generally, an easement would be found facially valid for purposes of a land use review. Again, this is your purpose, land use review. We're not deciding the relative rights and restrictions and everything else of the meaning of the easement. It's just a very facial first level analysis. So, If the easement was granted in a written document between two or more persons or entities indicating the intent of one or more person or entity to allow the other person entity some right to use a described parcel of property. Additionally, the hearings officer finds that a facial review would include a review of the document to confirm it was signed, executed. The hearings officer finds that if the easement is facially valid, then the hearings officer may also, in the context of a land use decision, review the easement document to determine if it contains a clear and unequivocal prohibition or restriction against the use being proposed in the land use action to be located on the easement parcel. That's where your conflict question comes up. There's nothing in there that says this type of use creates a conflict. Conflict is a vague term. You know, I can argue on one side of what I think conflict means. You had a question that was slightly different, and then the appellant's attorney said something else. We're not authorized in this setting to dig that far in. You know, we can't do that. The only thing, and the hearings officer is an attorney, he's a land use attorney, he's been doing this for many, many years. You know, facially valid, there is access. If we wanted to debate back and forth, we've spent hours before you guys today. You know, this is not something that you have authority as the quasi-judicial hearings body.
I understand your argument,
Yeah.
so unless the other commissioners want to hear more, I understand what you're saying.
Okay, I'm just trying to be really thorough because it seems like there's been a few questions on this.
Yeah, I think it is a question. I understand. I think you've been articulate in explaining your position on it. So.
Great. All right, well, I think that that covers the things that I wanted to address in the notes that I took from the other presentation. Mike, if my client can have just a couple minutes, if he has a couple of things to add.
Are you good with that, commissioners? Yes? Okay. You know, to wrap this up, and I don't want to stray from this, but this retail site gives you guys a solution to a problem that you have. You have a blanket over your county that is like Harry Potter. It's an invisible cloak that the medical system is working under. And if you allow this retail site to exist, then you are then able to go and approach that problem area, that problem child down the road. We have spent a great deal of time understanding what it takes to be a safe and efficient delivery system going forward, and I will work with you. What hasn't been addressed is I knew about ODOT when I bought the property, and so what I did was I walked into ODOT and had a meeting. What are you guys doing with it? Well, we have these things on the table. Great. When we get our approval, you're our next stop, because I'm not going to start something to waste the taxpayers' money and my time. So that's my next stop, is into ODOT. I'm very aware of that. I'm also very aware of the makeshift trails that are behind Tumalo, because I've walked them to understand the barriers that are between the proposed site and the actual trails themselves. They're not part of what is legally considered the setback, but I wanted to see and feel what it felt like as a normal citizen walking those trails with my boys. It's not there. There's so many barriers to getting to that property, 2 fences, another person's business, and a beehive station, that nobody's going to, no child is going to see the dispensary, and nobody's going to see people coming in and out of the dispensary even when they're taking their children to school from Tumalo. How do I know? Because I used to take my boys to school and pick them up every day. So I have done the due diligence for 3 years. I'm not an outsider. I'm telling you as a community member and as somebody that's verbally shook your hands that I will do what's right. We can't go off of what ifs. We have to go what is present and what makes sense per the law.
Thank you.
Thanks, that's great.
Any questions?
No questions. Thank you very much.
Mr. Dare, any questions? No. Thank you. Thanks for going through those issues and giving us some
Appreciate your time.
more enlightenment. So with that, I think we've completed the oral testimony. So let's talk about our next steps.
Yeah, so next steps, options are to continue the oral testimony, the portion of the public hearing, to a later date certain. You can also choose to close the oral portion and leave the written record open. Also could consider closing both the oral and written record today and deliberate at a future date, or do all today. I do know I didn't hear or haven't read a specific request to leave the written record open. However, there has been comments wanting to review submittals that have been in today.
So, yeah, I would think.
Yeah, the board's not compelled. This is the second public hearing, so you don't have to hold the record open. That's only if this was the first public hearing. That being the case, if the applicant is amenable to holding it open, that would extend the timeline that amount of time. And I would suggest if there's going to be consideration to hold the record open, I'm not sure that the 777 would be what I would recommend. I might go more on a 14-14-7 or something of that nature, simply because there were a lot of legal issues that are going to require some time, both of the attorneys and of your own legal staff, and I don't know that the 777 is going to appropriately allow for that. But that's obviously up to the applicant.
Yeah, that's what you're saying. So you can
You mentioned this isn't the first public hearing. You're referring to the hearings officer public hearing and now this.
Right, under the statute, if someone asks to hold the record open, it's mandatory if it's the first public hearing. If there's been a prior public hearing, it's discretionary on the part of the board on whether you want to hold that record open. In this case, if the applicant's amenable to it, it extends the 150-day clock, that corresponding amount of time. And I'm just suggesting if we go there that 7-7 is going to be really tight on the lawyers and your legal staff to answer some of these deeper legal questions that have come up in this application that certainly weren't vetted as deeply or as broadly in some of the previous applications.
Is there any request or feedback from the applicant, I guess is my thought. So I would lean towards an open record period,
Yes.
but yeah, what's your thought?
We were just conferring, and we were agreeable to leaving the record open, whether it's 7-7-7 or 14-14-7. I think
Okay.
either option is agreeable to us,
Okay.
whatever the commissioners.
Willis, do you have any comments on that? We're talking about the, for additional written testimony, we would allow a period of time after today's hearing to give additional.
Yes, Your Honor, and whatever the commission desires. My only problem is counsel is correct. You know, this was the second time this was set, and I've made a lot of adjustments, so I've got some tough schedules. 14 days would be much appreciated. I assume their 14 days would go first, and then I don't know how you're going to do that.
Well, it's actually a 14 days where either side can put in, and any citizens can put in whatever. Then there's 14 days to rebut anything new that comes in. And then there's a 7 or 9 day, or 14 days to do the final argument.
Timing's fine. I do have this question, though, since we're the appellant. I realize they're treating the applicant as going first and last, but we are the appellant. I would like to have some final word.
Well, this is a de novo hearing, and so the applicant has the burden of proof. Even though you technically appealed it, the burden of proof is with the appellant.
Thank you. Understand the reason for that now. Thank you much. Yeah.
Well, I'm fine with with the 14, 14, and 7. If
That suggestion.
with that suggestion, there were some things that still are pretty new to us, and there may be some good comments. There's a lot of good testimony. So, does that sound reasonable? Okay.
I support it.
Okay. So, and it's fine to do the last period is just 7.
Yeah, certainly, and the applicant's amenable to that.
So do we need to vote on that, or we just go forward?
Well, you can direct staff to proceed accordingly. Could you give the dates and times and all
Yeah,
that?
happy to outline those time periods. For the initial new information record closes at 5 p.m. on March 27th. The second rebuttal time period closes at 5 p.m. on April 10th. And then the final argument from the applicant closes at 5 p.m. on April 17th.
And then those dates, that 35 days is extended because the applicant's amenable. That extends the 150 days, those 35 days on top of that. So I don't know if you did that math, but if you could maybe do that and tell us when that 150th day now would be deemed. And just for people to be clear, the first window of time is for anybody to submit anything. I used to say you could submit a picture of your dog if you wanted. That's fine. Anybody submit anything. The next 14 days is for anybody to rebut anything that came in that first 14 days. And then the final 7 days in this case is for the applicant for legal argument only factual as well, but argument only, no new evidence, and it's because it reflects that they have the burden of proof as the applicant.
Bear with me while I get the appropriate new date. So with the extension of 35 days to the review time period, the final day for county decision is now June 20th. With the extension of the 35 days, the final day for county to render a final decision is June 20th of this year.
Okay. Great. So we've got our dates. Any other questions? Or I think that concludes this matter, and that was our final action item, I believe. So we'll continue upstairs with our work session. 2:30 or 20 minutes? Try to get something to eat. Okay. Thank you all for coming today and participating in this, and for your patience.
Yeah, no, that's What did you always do?
Interesting.
Oh, well,
Yeah, I don't know.
yeah, if I
I don't
could
know what
break,
they were
try
doing
and do
here.
that one.
I know.
That was so odd.
Plan on, yeah.
He's such a